argument on supplementing the record and admissibility of further evidence, should the court so direct. Our position is crisply stated in our heads of argument on that issue. I merely point out that as far as we are concerned, we understand that page 98 of the replying affidavit has finally made its way to the court, and we apologize both to the court and to our learned friends for the inconvenience caused. Let me then immediately commence with available resources and progressive realization. Justices, at the heart of this matter, we submit, is a fundamental divergence of political, economic, and legal theory. On the one hand, there is the laudable desire, which is shared by Treasury, to widen the net of social assistance as much as possible. The divergence is how to achieve that end and which branch of government can or should do so. Treasury has set out in considerable detail that it simply cannot afford to do more, having regard to the multiple demands on the government and the depressed state of the economy. The IEJ says it can do more. All that it has to do, says the IEJ, is to increase taxes or borrow more money. And critically, it says this court should endorse that approach. We will submit that the IEJ's stance is based on a misconception of both the nature and enforcement of socio-economic rights and the separation of powers. The attack on the various regulations and its acceptance by the High Court must be approached in the context of the extraordinary complexities of the competing demands on the state's resources. The High Court dismissed Treasury's concerns in this regard without a proper evaluation of the evidence and without a proper appreciation of the limits of judicial intervention in complex matters of budgeting and the need to balance a multitude of competing claims. Despite numerous cautions by the Constitutional Court, in cases like Subramoni, TAC, and Mazibuko, the High Court weighed in on the national budgeting process, ignoring the warning that courts are not institutionally equipped to decide how public revenue should most effectively be spent or to adjudicate on highly complex issues of social and economic consequence. That caution by our courts is scarcely surprising, given the massive complexity entailed at both a policy and a legislative level when it comes to budgeting and spending priorities. To appreciate just how complex that budgeting process is, we draw the court's attention to Chapter 4, that's sections 26 to 31 of the Public Finance Management Act, and particularly Section 27, subsection 3, which sets out in detail what the budget must comprise. And it prescribes a long list of things which have to be taken into account: estimates of the revenue expected, estimates of current expenditure for the financial year, estimates of interest and debt, estimates of capital expenditure, estimates of revenue excluded in certain categories. The list goes on and on. And it's not only the Public Finance Management Act. It has to be read together with, for example, the Money Bills and Related Matters Act 9 of 2009, which in Section 7, subsection 2, says that in addition to the information stipulated in Section 27 of the Public Finance Management Act, the documentation tabled by the Minister with the National Annual Budget must include, and then another lengthy list of things: proposed fiscal framework, key macroeconomic assumptions, interest and debt, estimates of capital expenditure, estimates of revenue, excluded in certain categories. The list goes on and on. And it's not only the Public Finance Management Act. It has to be read together with, for example, the Money Bills and Related Matters Act 9 of 2009, which in Section 7, subsection 2, says that in addition to the information stipulated in Section 27 of the Public Finance Management Act, the documentation tabled by the Minister with the National Annual Budget must include, and then another lengthy list of things: proposed fiscal framework, key macroeconomic assumptions, and so on. And that's by no means exhaustive of the statutory framework. There are many other statutes which regulate what goes into the budget, including statutes like the Adjustments Appropriation Act 49 of 2024, the Interprovincial Fiscal Relations Act 97 of 1997. These are deeply complex legal matters. But at the policy level, the evidence from Treasury establishes that there has been a concerted effort to address the problem of poverty. Treasury is acutely conscious of, and I use its words, the extreme levels of poverty faced by too many South Africans. And it has an appreciation which lies, as they put it, at the root of much of its approach to the budget as a whole. I will give you the paragraph numbers in the answering affidavit. They're all in volume 4. That was at paragraph 11. And at paragraph 15 in the answer, Treasury says that South Africa has one of the highest fiscal spending on social protection of any developing or emerging market country in the world. Between 2014 and 2027, South Africa has or will spend between 55.8 and 61.6% of its total budget on what is defined as the social wage, which includes social security and the fulfillment of various other socio-economic rights, such as education, health, and housing. This approach arises, that's at paragraph 15. This approach arises in the context, as Treasury explains, of a dramatically weakened fiscal position of government in the last decade, and more spending, the absence of economic growth, and rising debt. That's at paragraph 17. And as is explained, government can only expend money it extracts through taxation. Borrowing money is nothing more than deferred taxation. That's at paragraph 16. And the demands of the state, again I use the words of Treasury, concern virtually every facet of society, including obligations flowing from the socio-economic rights in the Constitution: access to adequate housing, access to healthcare services, sufficient food and water. The list literally goes on, and all this in circumstances of a relatively small tax base, a problem of tax evasion and non-compliance. That is in paragraph 18.1. Treasury says that further or continued expenditure on the SRD grant, by definition, must come at the expense of some other expenditure. That's in paragraph 37. And contrary to the approach adopted by the High Court, Treasury put up detailed evidence of the state's multifaceted approach to the problem and the plans adopted to address it. And it explained the fiscal constraints under which it operates. The availability of resources is, of course, a critical qualification of the state's obligation to progressively realize the right of appropriate social assistance. Those constraints are set out in considerable detail in Treasury's answering affidavit over nearly 30 pages under the heading "The Treasury's Approach to Social Assistance," and those are set out in paragraphs 10 to 54. And I cannot obviously do justice to everything contained in those pages in oral argument, but the gist of it is simply this: Treasury's medium to long-term plan is to facilitate and promote economic growth in order to create jobs. This is presently accompanied by huge expenditure on social assistance. And the dilemma facing the state is expressed in the following way in paragraph 24. It is said, "It is unrealistic and counterproductive to commit the state to providing significantly more resources to grants, as opposed to investing more in creating opportunities for people to have sustainable livelihoods. Social assistance, at least in the form of relevance here, is meant to be a stopgap measure while people are enabled to become economically active. The unfortunate truth is that the two problems are inextricably linked. The fewer people who are economically active, the less resources available to the fiscus. And the fewer resources available, the less the state is able to assist the poorest of the poor with social assistance." And in its approach to addressing the problem, Treasury describes a range of policy initiatives and plans, all of which must be taken into account as part of the obligation of progressive realization. That is because, as Treasury explains in paragraph 23, the problem of the inability to support oneself is a function of many factors, the most prominent one being unemployment. To address this, causal factors, which include economic growth, skills building, prioritization of specific groups of people in the provision of employment opportunities, education, training, and others. And pursuant to that approach, and you will see this in paragraph 23 together with its annexures, there have been a number of plans which are already in place. These include the South African Economic Reconstruction and Recovery Plan, the Employment Tax Incentive Act 26 of 2013, the Expanded Public Works Program 2019 to 2024, and the policy entitled Putting South Africa to Work, an Integrated Approach for the Working Age Unemployed. And in addition, Treasury has commissioned the South African Labour and Development Research Unit, SALDRU, to investigate a range of issues concerning social grants, including the replacement of the SRD grant with a family grant, the introduction of a job seeker allowance, and other related matters. You will see that at paragraph 27. And over and above these initiatives, Treasury refers to others, including the National School Nutrition Program and the provision of free basic services for water and electricity. You will see that in paragraph 51.8. What then is the IEC's answer to affordability? The IEC offers respectfully a beguiling answer. They say that by promulgating regulations that confer legal entitlement to recipients, government must be taken to have determined that it can afford the SRD grant, and thus by implication, affordability is not up for debate. They say that in their heads of argument at paragraph 103. But that argument simply ignores the evidence which establishes in the supplementary affidavit from Treasury that when the 20 Rand increase was mandated, the country's financial position had deteriorated further. The increase meant that the state had to cut other expenditure to give at least some further relief. The increase was the product of a reweighing of priorities, and the way it was put, and this is in the Treasury's further affidavit, which is in volume 9 at paragraph 14, they said that the increase in the grant resulted from a reweighing of priorities, which essentially includes a balancing act. As already explained by National Treasury in its answering affidavit, every time that money is spent on social grants, it compels less expenditure on other budget items. That explanation was entirely ignored by the court below. Apart from this, the IEJ's argument fails at three further levels. First, The question of affordability goes substantially beyond the limited question of the 20 Rand increase. It extends to the wider relief sought by the IEJ, which, if granted, would require additional expenditure between 93 billion and 139 billion Rand. Secondly, the IEJ ignores that the particular SRD grant was expressly time limited in Regulation 5.1 to a specific lifespan. And third, the argument is premised on the notion that the grant can always be made affordable by raising taxes or borrowing. That, we submit, is an artificial and unsustainable notion of affordability.
Right, Mr. Marcus.
Thank you. That lays the foundation, Justices, for what I want to say about Orders 14 to 19, because those are the ones which really are premised on the argument of progressive realization. And we deal with those together because they all flow one from the other. The attack on the value of the grant, the income threshold, is precisely what informs the structural interdict which followed. There is, at the outset, Justices, a material misdirection by the court below, because the learned judge found that the minister had not put up any explanation for the increase of the grant to 370 Rand. That you'll see in the judgment at volume 10 at paragraphs 146 to 148. But that's not correct. The minister had put up an affidavit to explain the increase, and that, we submit, was a clear misdirection. That affidavit is the supplementary affidavit to which I have referred. It's in volume 9 at pages 1635 to 1643. At the heart of the attacks on Regulations 2.5 and 5.1 is the contention that neither the value of the grants nor the threshold value have been progressively realized because, so the argument goes in essence, neither have kept pace with inflation. Hence, the argument is that the value of the grant today is lower than it was in 2020. So at root, the argument advanced is that the retrogression in value is a failure of progressive realization. And on this argument, of course, not only the SRD grant, but indeed all grants would have to be increased in value to keep pace with inflation, or at least run the risk of being in breach of Section 27 of the Constitution. That is one of the central arguments of the IEJ's case. And we would respectfully submit that there are 5 flaws in that argument. This is the argument that, absent keeping pace with inflation, the value of the grant today is less than it was when it was introduced. Therefore, that is retrogression. The first reason is that it ignores the requirement of available resources. Indeed, it eliminates any inquiry into available resources altogether. It says that there is an obligation to increase the value of the grant to keep pace with inflation, irrespective of whether there are resources available to do so. Secondly, we submit that it seriously and impermissibly intrudes into the executive's policy-making functions to determine priorities when it comes to matters of social assistance. Indeed, the argument comes close to usurping that function, and at the same time, it seeks to involve this court's sanction to do so. It seeks to tell the state that what is envisaged, or what was envisaged as a temporary grant, must not only be retained, but must be increased. And that is contrary to the jurisprudence on progressive realization. Grootboom at paragraph 41, Causa at paragraph 48 make clear that the precise contours and content of the measures are primarily matters for the legislature, and a court considering the reasonableness of such measures will not inquire whether other more desirable or favourable measures could have been adopted or whether public money could have been better spent. The third flaw in the argument is that it entails a narrow, a myopic approach to progressive realization, because what it does is, instead of posing the correct question, and that is whether the state has generally complied with its obligation to progressively realize the right of access to appropriate social assistance, it focuses on only one of 8 social grants, and it ignores entirely the range of other measures, which I've already outlined, to alleviate poverty. These are all other measures envisaged by Section 27 of the Constitution. The wording is specific. Progressive realization is achieved by legislative or other measures, and these are all other measures adopted to pursue progressive realization. But even if we are mistaken in that last submission, and it were permissible to look solely at the SRD grant, the argument ignores the fact that there has been progressive realization of the SRD grant in 3 respects. First, the very introduction of the SRD grant in 2020, where none existed before, is itself an instance of progressive realization. Secondly, the change of the eligibility criteria in 2022, when the threshold was changed from 350 Rand to 624 Rand, thereby substantially expanding the pool of beneficiaries, was itself a significant progression. And thirdly, as we know, there was an increase in the value of the grant, albeit a small increase, but that too was a progressive realization. So that's the 4th reason why this argument fails. And then finally, the 5th reason is this. Our learned friends rely for their argument on retrogression mainly on the judgment in the case of Commando versus City of Cape Town. And I'd like to just make a couple of submissions on that case, given the emphasis that our learned friends place on it. The first is that the facts are very far removed from the present case. It concerned the eviction of lawful rent-paying tenants of many years' standing who had resisted forced removals. This was in Cape Town. And it occurred after a private developer had acquired the property and obtained an eviction order in the High Court. And negotiations between the evictees and the city broke down on the question of alternative accommodation. The breaking point was that the city had not built emergency housing in the inner city for 30 years and was thus offering to relocate those evictees to some 15 to 30 kilometers away. So it was this deficient housing program which was declared unconstitutional. So I'll make the simple point that the facts and context are very different. Perhaps more important is this. The IEJ places particular reliance on the judgment of Acting Justice Bilchitz and his approach to the two-element theory of non-retrogression. But the judgment of Acting Justice Bilchitz was a minority concurring judgment by him and one other. They also, in fact, concurred in the majority judgment. The principal judgment does not adopt the same approach as the minority. The majority explains its finding on retrogression in paragraph 103 of that judgment. Let me just read it to you, and then the comparison will become apparent. What they said was this: it is cold comfort that the city does not make provision for temporary emergency housing programs within the inner city. The city should have foreseen in its planning that urban regeneration would lead to displacement. Its conduct was unreasonable because it failed to mitigate the effects and consequences of gentrification on the most vulnerable. It in effect forced the most vulnerable out of the city. This is a retrogressive measure, particularly in the light of South Africa's history. So what one can see from that passage, and that's the only paragraph in which the majority addresses this question, there are three components of the court's reasoning. The first is that the city made no provision at all for emergency accommodation in the inner city. Here, the state has manifestly made provision for social relief from distress in the form of a specific grant, but not only in the form of a specific grant, together with a whole range of other programs to which I have referred. Secondly, the court found that the city ought to have foreseen that the absence would lead to displacement. Here, the state has plainly foreseen the wider effects of poverty and has put in place a range of both legislative and other measures to address the problem. And the third leg of the reasoning was that the city had not taken any steps to mitigate the effects and consequences of gentrification. Here, the state has a variety of plans, legislative and otherwise, to address the problem. So the situation here is simply not comparable. The second element of our learned friends' argument is this. They adopt the argument that, or they ignore the argument in their approach to retrogression, that the SRD grant was intended to be only temporary. That is a fact repeated throughout the answering affidavit. And the finding of retrogression and the consequent orders, those are 14 to 19, rest on the wrong factual premise that the grant is permanent and thus falls to be treated like all other grants. And that brings me to the IEJ's equality argument. A constant theme of the IEJ's argument is that all social grants are conceptually the same and thus must be treated the same. On this argument, since the other grants have been increased, and that is factually correct, but not the SRD grant, this amounts to a form of unconstitutional differentiation. That argument, we respectfully submit, fails for three reasons. The first is the central premise of the argument that all grants are the same. That is incorrect. Obviously, if the premise fails, the argument fails. But the SRD grant was introduced as a temporary measure under the Disaster Management Act, which by definition was intended to have a limited life only. Under the Disaster Management Act, there are specific periods for which disasters can be declared, and measures taken pursuant to disaster have the lifespan of the disaster alone. The current regulations stipulate that their currency is limited in Regulation 5.1, and that is consistent with the Minister's evidence. The second point is that SRD grants are legislatively treated differently from the other grants. The Act in Section 1 defines social grant and social relief from distress separately. The definition of social grant does not include social relief from distress, and whereas the social grants as defined are prescribed in Sections 6 to 12 of the Act, social relief from distress is regulated by Section 13, which leaves it to the Minister to prescribe by regulation. So social relief from distress is treated differently from the other grants, and in accordance with the general principles, a change in wording is to be regarded as prima facie a change in intention. Many cases say that, but let me give you the case of R versus Sisilani, which is 1959, volume 2 of the South African Law Reports, page 448, Appellate Division, at 453F. And thirdly, at the level of fact, Treasury explains precisely why there are conceptual differences between the different kinds of grants. They say in their answering affidavit in volume 4 at paragraph 95 the following: "It is perfectly reasonable to take the view that inflationary increases, to the extent affordable at all, should be prioritized for grants which are expressly permanent and which have been in existence for decades, and which are by definition the only means of support the recipient will ever receive. In other words, since a child cannot by definition work, he or she is entirely dependent on a child support grant to survive, of course assuming that he or she is not adequately supported by a parent or guardian with sufficient means. By the same token, a pensioner cannot be expected to find work as an alternative to receiving an old age grant. The recipient of the SRD grants are by definition of working age." So that is our argument on progressive realization orders 14 to 19. Let me then turn to the regulations, and I want to say something by way of introduction to the regulations. And it's an important stepping stone to the argument that we advance. It's that the right to social security in the Constitution has an internal limitation. It is only available if a person is unable to support themselves or their dependents. That is a definitional limitation of the right in Section 27 itself. This means that the very terms of the right necessarily postulates an inquiry into whether the affected person is unable to support themselves or their dependents. And several of the regulations under attack are intended to achieve that fundamental purpose. It is also echoed, by the way, in Regulation 2.1, which stipulates that eligibility is limited to persons, and I quote, "with insufficient means as defined." And of course, I'll get to the debate around that in a moment. The IEJ rightly accepts the need for safeguards against abuses, and that is an important concession on their behalf, because the regulations with which we are concerned, database verification, online applications, etc., are all in one or other way designed as mechanisms to curb abuse. But the state's concession, not the state's, the IEJ's concession that safeguards are necessary is an important one, because the yardstick of reasonableness vests the state with a range of options, and provided the means chosen fall within that range, there is no scope for judicial interference. And that is why the Constitutional Court, for example, in Mazibuko, the water case, accepted that means testing was a reasonable measure, for otherwise it would deprive government, this is their words, of a key methodology for ensuring that government services target those most in need. The court further held in Mazibuko that although means testing may not be perfect because it is under-inclusive, this fact must, and I quote, "yield to the indisputably laudable purpose served by means testing. It seeks to ensure that those most in need benefit from government services." That's all at paragraph 101 of Mazibuko, and that we submit is at least the conceptual answer to much of our learned friends' argument. It is not in dispute that in any reasonable system, anywhere in the world, in which public money is used to provide benefits to members of the population, procedural safeguards are adopted to ensure that only those to whom a particular benefit is due may receive it. That is said in answer, Volume 4, paragraph 76.1, and it is not disputed even in reply in Volume 9, paragraph 223.7. That, of course, is respectfully basic common sense, and it serves to prevent fraud, and it ensures that the budget is used properly. That is how it was put in answer at paragraph 76.2. And then comes the issue which is simply a fact of life. As Treasury puts it at paragraph 77.8 of their answer, it is close to impossible to adopt procedures which are capable, without any exceptions and errors, of ensuring that every deserving recipient of public funds receives them and every legitimate claim is weeded out. That is simply absolutely impossible, particularly in a scheme of this magnitude, and that is why, as Treasury puts it in the same paragraph, some compromises have to be made. With that preface in mind, let me turn to the four regulations which we defend, and let me hasten to add, my learned friend for social development will elaborate on some of these, and I will be relatively brief.
Mr. Marcus,
Yes.
before you move off this point, let us just deal with what constitutes insufficient means in terms of
2.1 of the regulations.
That was going to be the second one I deal with,
okay.
but
So-
can I just get rid of online applications first? It will take me a minute, Justice, and I'll get to that very shortly. The attack, this goes to Order 1, and this is the use or the prescription that applications must be made by means of an online platform. And the legal question is really a straightforward one. It is this: is the requirement of online applications reasonable inasmuch as it is a measure which is designed to minimize fraud and wastage and to ensure that eligibility criteria are met and which promotes efficiency? That is the justification advanced for it. We recognize, as we must, that it is one of those areas in which compromises have to be made because no system is perfect. The IEJ says, well, that's not good enough. But recall that the reasonableness component of progressive realization does not inquire whether other more desirable or favorable measures could have been adopted. In other words, imperfect as it is, the court will have to reach the conclusion that, notwithstanding those imperfections, it crosses the threshold of unreasonableness. So,
people without the means to even buy a cell phone. There are many people that is not able to use electronic platforms. Why can't they go to the SASA offices and be assisted there?
it's a fair point. I can't readily say to you any more than I have already said in that regard. Other than this, my learned friend for social development will elaborate on that, because my understanding is, I don't want to intrude on his argument, is that social development has taken steps at those offices to assist with the facilitation of applications, but still by means of online platforms. Yes.
People at their offices online.
My understanding is that that is one of the processes which are in place, but may I leave that to my learned friend to address.
That is
The kiosks that are in those specific offices, and that is online as well.
Correct. Can I make one other point? We do make it in our heads. And it's an argument which I appreciate has got its limitations. It's the point that flows from the case of Van Heerden versus the Minister of Justice. It's the Constitutional Court decision. We do refer to it in our heads. which makes the simple proposition that legislation must be assessed by way of the majority of cases to which it applies. Now, that was a case which involved an affirmative measure adopted by the first Parliament after 1994 to provide pensions for those who, by virtue of race, had been excluded from ever being parliamentarians before. And approximately 10% of the eligible recipients of this measure were what were referred to in the papers as the jammer gevalle. They fell through the cracks. And the question was whether that 10% was of a sufficient magnitude as to invalidate the scheme as a whole. The Constitutional Court said it didn't, because legislation is directed to the majority of cases. Not every single case, but the majority of cases to which it applies. But Justice Mayor, your point is taken, and the question will ultimately be whether a combination of applications on the electronic platform and using an electronic platform, albeit at the kiosks, at SASA offices, suffices or not. If it doesn't, our argument will fail.
My concern is
That I understand the premise on which legislation allowed for online applications because it was the COVID period. So clearly there was no contact in that period. But having come out of the COVID period, what has been done to now supplement and amend legislation to also cater for those, as has been put by my brother, those who don't have the facilities or the means?
My understanding, you pose the question, what has been done? My understanding is that what has been done is that kiosks for that purpose are being made available. In what number, to what extent, I can't answer. Perhaps my learned friend could do so.
Somebody that can assist people who is not able to work electronic platforms.
And I cannot dispute the logic of what you're putting to me. I can only say to you that the magnitude of the issue is so huge that inevitably, as the Treasury puts it, compromises do have to be made. The question is, how can those exceptional cases, I think that's the proper way to put it, how does one address those exceptional cases? Can I then get to Justice Hughes's question, that is the meaning of income and financial support. You will know that the High Court adopted the argument advanced again by our learned friends before you, that you have to read those terms as including two components, as including the requirement of regularity and the requirement of obligation. We do not need to debate in this court the process of interpretation, which is well known. But let me start with text, because that has frequently been said to be the interpretive starting point. There is simply no warrant for reading into those requirements, into those definitions, the requirements of regularity and obligation. The high watermark of the IEJ's argument on text is to refer to an internet definition given in the Merriam-Webster dictionary, but without quoting that definition. In the High Court, they referred to other definitions from other dictionaries, but none of them supported their argument. And even a consideration of the Merriam-Webster definition shows that regularity and obligation are not inevitable. Thus, as a noun, it is defined in the Merriam-Webster dictionary as, and I quote, a gain or recurrent benefit usually measured in money that derives from capital or labour, also the amount of such gain received in a period of time. But for purposes of our argument, we can accept that depending on context, the word could include but is not confined to regular and obligatory payments. The real question is whether its meaning in a context, whether it carries that meaning in a context where a grant is payable only to those who cannot sustain themselves. That was my introductory argument. The unmistakable purpose is to limit payments to those who cannot support themselves. So the inquiry must be whether they are in receipt of any money, regular or otherwise, obligatory or otherwise, to support themselves. So there's a real sense in our submission in which the wrong question is posed by our learned friends. The question is not whether income includes regular and obligatory payments. It plainly does, and we accept that. The real question is whether income excludes ad hoc receipt of money or donations or the like, and we submit it plainly does not. And that's really the essence of our argument. It's a textual and a purposive interpretation, bearing in mind that the right and the regulations themselves have an inbuilt limitation. And we submit, therefore, that the High Court was mistaken in adopting that argument. Then there is the use of bank and database verification.
So, Mr. Marcus,
Yes.
in respect of the income, that would include donations.
Nations.
Yes.
So the reliance would be, well, in my view, would be on a declaration from the applicant themselves saying that X amount in my bank account is a donation.
Yes, what's held by me on behalf of somebody else. It's not for my use. And certainly, Justice Hughes, the way you put it would be one way of an applicant saying, look, this is not my money, or it's not for my use, or whatever the case may be. And bear in mind, this is a month-to-month thing.
I was just getting
Yes.
to that.
Yes.
So,
In a month, I hold money on behalf of X. And in that month, the way I read the papers is that in that month, if I have over the threshold in my bank account, I do not get the grant. Right? So just let me finish my... So that I don't get the grant for that month. Then I lodge the appeal. But for that month, I do not have the finance that the grant was supposed to distribute to me. And I only get it after the appeal stage, having submitted that no, the money belongs to X.
Yes. Once again, Justice Hughes, I cannot exclude that possibility. You might criticize it as an imperfection in the system, but you're dealing with multi-million numbers in applications. There needs to be some form of administrative efficiency. Otherwise, the system will collapse. There has to be some mechanism which deals with the majority of cases to which these applications apply. But if you're putting to me that there can be exceptional cases, I cannot disagree with that.
By allowing evidence on internal appeals.
Yes. My learned friend will address that. You will know that the Treasury's attitude in that regard is we did not oppose that particular matter. So I'll leave that to my learned friend. My learned, I know, again, I'm not foreshadowing his argument, but I do know that his argument extends to demonstrating, if he can, that the High Court misunderstood the scope of the appeal. But the answer to your question, Justice Mayor, is yes.
So if I understand your submission, Mr. Marcus, you accept that there may be exceptional cases where bank verification and other, obviously the money would show it's not coming from UIF, the other databases would show, but if you get money that belongs to someone else, if a proper appeal process were in place, it would result in a delayed payment of the grant, not a total exclusion.
As a matter of logic, I have to accept. Can I?
And again, you would say it's still a reasonable measure.
Yes.
Is that?
I want to make that very point, if I may. It's on the use of bank and database verification. You've got to appreciate in our submission that the IEJ's objection is not a principled objection. If you have a look at what they say in their heads of argument at paragraph 56, they say the respondents do not oppose it, that's database verification, in principle, but only its implementation in light of the high degree of inaccuracy and levels of errors confirmed by the appellant. So it's not a principled objection, it's a question of how it's implemented. But of course, in an attack on the constitutional validity of a regulation or a law, the fact that a particular provision might be abused is not a ground which goes to unconstitutionality. In our heads, I think we quote the case of Van Rooyen versus the state. I'll just check. But that's the case. Let me just give you the reference. It's 2002, volume 5 of the South African Law Reports, page 246, Constitutional Court at paragraph 37, where the point was made that any power vested in a functionary by the law, or indeed the Constitution itself, is capable of being abused. That possibility has no bearing on the constitutionality of the law concerned. The exercise of the power is subject to constitutional control, and should the power be abused, the remedy lies there and not in invalidating the empowering statute. There's a second argument which I should allude to, which is advanced by our learned friends. What they say, and I quote from their heads at paragraph 61, they say that the department, and I quote, do not have to employ bank verification. They could instead deploy methods used for other means-tested social grants, including self-declarations requiring documentary evidence of income and financial support and random checks. That's their argument. But that's respectfully simply question begging. The question is not, and I've stressed this before, it is not whether other methods could be employed. It is whether the chosen method is constitutionally objectionable. And I once again refer in that regard to Grootboom at paragraph 41 and Causa at paragraph 48, where it is stated that that is not a matter for the court to determine. That is, whether or not other desirable or more favourable measures could have been chosen.
Yes, because that will be moving into the realm of the executive.
Exactly. That brings me lastly to the enigmatic, I do say enigmatic, Regulation 53A, and that's the limitation that payments are limited to the amount appropriated in the attack on in this case, to the amount appropriated to the 2024/2025 financial year to the vote of social development for social relief from distress. What our learned friends contend is that this limitation is irrational or arbitrary, because if the money runs out, parties who would otherwise be eligible would not receive their grant. Now, they're absolutely correct as a matter of logic that that is indeed the outcome. But that is not an outcome that is irrational or arbitrary. It is the logical conclusion of what would occur if the money did run out. In a sense, the qualification that is expressly built into this regulation is an implied qualification in relation to almost any grant. It is subject to, if money runs out, let me put it bluntly, if money runs out and grants which have been promised can't be paid, then the state faces what is probably known as a fiscal crisis. But it's a logical conclusion. It's not desirable, it's not a happy state of affairs, but it's the logic of what happens if money runs out.
Relief grant is annually approved by the amount of it, and whether or not there will be one is annually approved by Parliament.
There is
that if one takes your argument to its logical conclusion, if we have got 500 persons in the queue and the money runs out on the 300, when it reaches 300, then the other 200 then it's just hard luck for them. They must go away.
That's the logical argument. I can't dispute that is indeed what would happen. But my principal argument doesn't go to the question of rationality or anything. The principal argument is that it's highly speculative. It's something that's never happened because the budget has historically never been exceeded, and no person has ever been turned away because the budget has run out. And that explanation is furnished in the answering affidavit at paragraph 53. I do want to just draw the court's attention to one.
In other words, the respondent and the applicants would have been then duty bound to produce evidence to the effect that there were these 500 eligible persons. Correct. And only 300.
Correct. It's never happened. It's never happened. So it is hypothetical in that sense. If you're going to ask me, could this never, ever, ever happen? I can't say that it will never, ever happen. But it has never happened, and it is therefore highly speculative. And it is really not the sort of issue which this court should pronounce upon.
Mr. Marcus, might it be challengeable if it did happen?
Absolutely.
But your point is it hasn't yet.
It's never happened. Yeah. I want to draw attention.
Sorry, Mr. Marcus, on that, as I understand the broad arch of the respondent's case, it hasn't happened because of the obstacles that are put in place.
Well, that...
And, sorry, just bear with me a little bit. And their argument starts further back. They start from the premise that that government has undertaken, it's accepted an obligation to pay this grant to employment age persons who are unemployed and unable to assist themselves, support themselves rather, and that the state accepts that I think it's 18.3 million people fall in that category, and therefore it's failing in its obligation by even setting a budget too low, coupled with putting obstacles in place to make sure that it remains in budget, the dispensing of the grant remains in budget. I'd like your comment on that premise.
Yes.
Obviously, you don't address it directly, but you address it in the way in which you've structured your argument. But
Yes.
the premise that the state has accepted, one, that there are 18.3 million. It's accepted an obligation to provide a grant for those, well, it's a social assistance for those people, and by setting the budget too low, and then by putting the measures in place, that as a whole constitutes an unconstitutional regression, really, of their failure to comply with their own obligation.
Yes.
That's what I understand their thesis to rely on.
That is indeed certainly their thesis, or part of their thesis. A number of comments, Justice Keatley. The first is, bear in mind, I'm dealing with an attack on a specific regulation.
No, I understand that.
Okay.
I do understand, and I just took this as an opportune moment.
No, fair enough. Then I understand the...
I mean, the thread comes through to all of the and particularly to this one.
Yes.
Because, you know, they would say, you've given an obligation in all of your policies, year on year, you've made this obligation. You've underfunded, and now you say that once it's gone, it's gone. And that can't be. You are reneging on a constitutional
Yes.
obligation.
No, that would precipitate a constitutional crisis were it to come about. I've got no doubt about that. I'm simply saying that in the context of this particular attack, it's never happened and it's hypothetical. But at the level of your broader,
on the premise.
question, it's difficult to separate out those attacks from their threshold attack and their grant value attack. I'm at the moment dealing purely with the attacks on the individual regulations,
Okay.
which have to be assessed according to established principles. But Justice Keatley, yes, you are correct. That is part of their broader argument. We, of course, dispute many of the factual premises underlying that argument. But since I'm dealing with the attack on the regulations, the springboard for our answer to those attacks is the realization that there is an inbuilt limitation, that there have to be measures put in place which determine who is eligible and who is not eligible, because that is the only feasible method to deal with budgeted money. I accept the proposition that they accuse the state of bad faith. They accuse the state of a mala fide scheme to exclude recipients. We do not accept that proposition. We say that such restrictions as are placed in the regulations with which I am dealing at the moment are perfectly legitimate and reasonable measures designed to ensure that only those who are entitled to receive the SRD grant do in fact receive it.
Is the SRD grant the only one which requires Treasury approval, concurrence rather, or do they all? Is that a standard?
All
of them do?
All of them do,
Okay.
yes. The legislative difference is the one I pointed
Yes.
to.
I just
Yes.
wondered if
No,
that...
No,
yeah, okay.
my understanding is that it's all. I wanted to just draw the court's attention to one thing, and I need to stress that I'm not making a point of it, but it's something that the court needs to bear in mind. There is I'll put it in quotation marks, a mootness issue in relation to Regulation 53A, for the simple reason that it has been replaced, as the court knows, by a new regulation, or two new regulations, which change the financial year, which governs the grant in question. So I'm not suggesting that for that reason the court should decline to pronounce upon it, because it's going to be a recurring problem. But I suppose it's merely a technical issue. Maybe my learned friend will have some ideas about it. It will go to the underlying reasoning. If our learned friend's argument is to succeed, I don't suggest that merely because the regulation has been replaced to cater for subsequent financial years that this court should avoid it. That is not my argument. It's a technical issue relating to the order that this court might make or that this court might confirm. Justices, I want to just I'll be very brief on remedy, because it's one of those situations where everything depends on what the court decides. But we stand by the argument we've advanced in our heads, and especially the suggestion that if the broad attack on threshold value and value of the grant coupled with the structural interdict were to succeed, the suggestion that we be given 4 months in which to remedy that is really utterly insufficient. The court knows more than enough to appreciate the complexity of the issue, and what is suggested by the High Court is really a wholesale reconsideration of fundamentals underpinning the social grant system. There is one aspect of that order which we respectfully submit simply cannot stand. And in that regard, it's the prescriptive nature of the order. We have referred in our heads of arguments to the Minister of Environmental Affairs versus the Trustees Groundwork Trust, the decision of this court. It's in our heads of argument at paragraph 77, and it's footnote 118. That was another instance in which this court rejected an attempt to box in the discretionary nature of a particular matter in that case, but the same principle applies here. The order of the High Court is extraordinarily prescriptive, and bear in mind, if that order is to stand, there will be questions of compliance thereafter, and not simply questions of compliance, there will be potentially questions of contempt. That is simply an impermissible constraining attempt to constrain how a very, very complex discretion should be exercised. There's one other case which is similar, to which I'd like to refer you. It's not in our heads, but it makes a similar point. It's the case of ETV, Pty Limited versus the Minister of Communications and Digital Technologies. It's 2023, volume 3 of the South African Law Reports, page 1, Constitutional Court, and it's at paragraph 89. And it was a similar situation in which the High Court had been very prescriptive in sending a matter back to the High Court, in sending a matter back to the decision maker, a particular decision had to be taken. And the court there made the point that the broader relief would invariably require this court to dictate to the minister that certain nuanced and specific steps must be taken. What the applicants are in effect asking of this court is to prescribe the procedure that the minister must follow before determining, in that case it was the analog switch-off date. And the court said this was really akin to an order of substitution. So it merely reinforces the point that we have made. In relation to everything else, as I say, almost everything depends on what the court does. If, for example, the court were to strike down Regulation 5.3, the one which limits it to what is contained in the budget, that's something that can be fixed relatively quickly. If it strikes down other regulations, depending on which ones they are, far more time would have to be required.
I know that in your head of argument you are asking for 24 months.
Yes.
But in the...
That would be for the plan, Justice.
Yes. Okay, the reason why I'm raising that, you did allude to the fact that the SRD grants, were conceived to be of a temporary nature and have now been extended to 30th of March 2027.
Yes.
And then what would be the effect if we are with you of an order giving you 24 months to address that? What happens if, come the 31st of March 2027, and social development says we've now reached the end of the road?
Justice Gibson, that would be a practical matter, and I would suggest that in that eventuality, it might be for the parties to come back to court and seek a variation of the order. But we should assume in favour of the IEJ that that scenario won't happen. I can't say as a fact that it won't. And we should make an order which is appropriate in the circumstances. That's the best I can suggest.
Thank you.
Justice Hughes, those are my submissions.
Oh, those are the submissions. Are there any questions?
It's tea time.
Yes, I know that. Well, thank you. You've actually hit the nail on the head because it's now time for us to go to tea. So we will take the short tea adjournment and we'll resume at 15:15.
Can I assume that I'm done so that I can swap places?
Yes, I was just coming to that. Mr. Eden, we'll hear from you after the tea adjournment. Court will rise.
paragraphs 3 to 15, social relief.
Yes, Mr. Eden. Mr. Eden, you've got the floor. Thank you.
First, we briefly explain why a fully automated online-only system for COVID-19 social relief of distress, SRD, is used. Then we turn to the specific orders the Court made to explain why the appeal should be upheld, to enable first and second appellants to retain the automated online-only system as it appears from the regulations. The SRD is dealt with in our main heads of argument in paragraphs 3 to 15. The fully automated online verification process is repeated monthly in the respect of 15 million applicants. You will find that reference in volume 6, page 1096, paragraphs 117, 118 and 125. The monthly verification draws a bright line between SRD and social grants, the latter being verified once upon it being approved by officials. As appears from the regulations, SRD is temporary relief, for the moment 12 months. But SRD is also temporary in that it is awarded only for a month at a time. Beneficiaries of SRD must qualify every month to receive payment, so a speedy verification process is required monthly before the beneficiaries can be paid. At the moment, approximately 8 million people. Depending on variables such as monthly income received into a bank account, a beneficiary may not qualify every month, a fact that was overlooked in the many supporting affidavits attached to the founding affidavit. I refer to one instance, volume 3, page 553, paragraph 4. The fully online system is, in the words of the answering affidavit, the method that has proven to be the most successful. That is volume 6, page 1082, paragraphs 63, 70, 79, 90, 246.3, 261.2, and page 1192, paragraph 71. The first and second appellants are proud of what they have achieved with this specific rollout. There are 3 critical stages in the fully automated system. That is the application stage, the verification stage, and the appeal stage. The safeguards and methodology employed in these 3 stages result in a reasonable and a rational online-only system. We explain these safeguards of each of the 3 stages when we deal with the specific orders made by the Court of Quo. The court orders requiring deviations from the automated online-only process impermissibly remove government's entitlement to retain these reasonable measures to meet its obligations. I now turn to the orders. Orders 1 and 2 are addressed in our main heads in paragraphs 16 to 36. These orders of the Court de Quo declared Regulation 3(2) unconstitutional and invalid to the extent that it allows for SRD applications to be lodged on an electronic platform only. The order requires DSD and SASA to allow applicants to be processed in person. In the main heads, paragraph 16 to 36, and we explain why that would be a regression.
Could you repeat those paragraphs again, please? The paragraphs, could you repeat the numbers? That's all I'm asking.
Paragraph 16 to 36 of the main heads, and then 37 to 52 deal with the regression of importing manual human input.
So 16 to 36.
And then 37.
Yeah, it's 37 to 52. When the COVID-19 social relief of distress was introduced in 2020, during the hard lockdown period, no human intervention was possible. But since then, the system has developed substantially. The whole process remains online only, but important safeguards have been introduced and improved over time. At the application stage, the following safeguards are of relevance. The rollout of self-help kiosks has been successfully completed, leaving SASA offices countrywide with self-help kiosks within its offices where applicants can access devices and internet connectivity. Here, communities are assisted with SRD applications. The reference to that, volume 6, page 1087, paragraph 82. Second, the free of charge call centers referenced in page 1190, paragraph 66, continue to provide for human intervention in the application process.
So we didn't hear that? The what?
There's a free of charge call center, and they continue to provide for human intervention in the application process. Thousands of queries are dealt with weekly. The reference is volume 7, page 1215. So although the system remains strictly online, human assistance is provided to those applicants struggling with the online-only process. In addition, and in the third place, there's also an email option that people make use of. That is page 1190, paragraph 67. Finally, SASA attends forums where information is shared. These forums are attended by civic organizations, including Pay the Grants. That is volume 6, page 1188, paragraph 60 and further. We submit, justices, that struggling applicants for SRD are therefore not left behind because of the safety net that has been created post the hard lockdown period.
When we deal with these
Safeguards that have been put in place. And this was after the lockdown period, I would presume, isn't it? Because now the kiosks are at the SASA offices, and there's also this call center. Has the DSD considered having walk-in options for those who are not literate who are not computer literate, I should say? Walk-in options to the SASA offices and dealing in person with a consultant, just like Home Affairs and the other grant offices. Has that been a consideration? Because that seems to be the concern of the respondents.
Just bear with me. When individuals attend at the SASA offices, they are directed to the self-help kiosks. So at what level there will be personal assistance there, it's not clear from the papers.
Are we asking the question?
But one would assume that when you have this system of safeguards, that there will be interaction between people at the offices. How else will it be?
But isn't that the kind of detail that should have been in the answering affidavit?
I beg your ladyship.
Isn't that the kind of detail that should have been? The court should have been given those facts. The answering affidavit says a lot about how proud it is of the efficiency, but I struggled to find facts that deal with how the system works. There wasn't really an explanation about the kiosks. And that, that was for that DSD thinks it's efficient isn't really the issue. We need to know, as a matter of fact, what is on the ground.
Justice Keithley, those affidavits were deposed to almost 3 years ago when the self-help kiosk was in a pilot phase. So there are continuous efforts to improve on the system.
You're saying that from the bar?
No, I'm not saying that from the bar. I'll give you the reference in a moment. But
sorry, I understand that was stated in the answering affidavit.
Yes. Please in mind, there are 15 million people on the system. So that the deponents to the affidavits say is the best social system that they have. So we submit that that online system brings huge benefits for the beneficiaries.
But what isn't explained or what isn't answered in the answering affidavit is what about those who might be blind, impoverished and in a rural area, for example, who don't have a cell phone? Or, that just we're not told why it wouldn't be possible or is it reasonable to have an alternate system that would expand the pool, not to go offline completely. It can retain its efficiency.
Yes, that is what happens when the self-help kiosks are used. It remains online only, but there's assistance to get what the problems were that were raised relating to devices and to internet connectivity.
But you see, that's the concern that the respondents have raised, and it wouldn't be excellent if the DSD could explain to the court that even I gather from the heads that you are moving towards some sort of a hybrid system. But the hybrid system still seems to concentrate on online applications, because even the kiosk itself is an online
application.
It is a full online system, and there's not a hybrid where people can access the SRD in another manner. They are assisted when they struggle with the application procedure, and I've dealt with the safeguards, the 4 safeguards, the community outreaches. There are forums where people come together, they discuss problems, but the online system is what is allowing DSD to reach 15 million people on a monthly basis. The human resources in DSD and SASA can never replicate 15 million people.
I think
I want to make sure that I understand the thrust of your submission, that applications are submitted online, but in relation to those applicants who are either unsophisticated, illiterate, computer illiterate, who choose to go to a SASA office to submit their application on the kiosks available there, would be assisted by a consultant to submit the application online.
Yes, that is correct.
where do we find that, Mr. Van Heerden? Where do we find that? Or are you going to give us the reps?
Volume 6, page 1087, paragraph 82. With the court's leave, it's just a short paragraph. Let me read it.
Excuse me?
The page? Can you give us the page again, please?
Volume 6, page 1087, paragraph 82. It's just a short paragraph. Let me read it. SASA has, within its available resources, implemented community outreaches where communities are assisted with SRD applications. SASA is currently piloting the use of self-help kiosks within its offices. Depending on beneficiary usage, the self-help kiosks may be rolled out in key strategic areas outside of SASA offices.
So it's
Piloting, or is
No,
it...
this is what I said 3 years ago.
Oh, okay.
And we understand that has continued and it
But it
successfully.
still doesn't say that they are helped in person, which was what my brother was asking you. And it simply says in our available resources. Is there anywhere in the affidavit that says that SASA cannot, on its budget, make human beings available to read an application and enter that onto an online system? Let the online system work, so the verifications be done online, subject to whether we uphold, obviously, the,
Yes,
so that you just, is there anywhere in the affidavit that deals with that, the resource issue?
Yes, there are places where there are complaints from SASA and DSD to explain that they haven't got the human resources, the infrastructure, etc. But what I'm dealing with at the moment is just the application stage. And what I submit is that the safeguards that we have in place at the application stage are such that struggling applicants are not left alone. They are targeted through the community outreaches, they're targeted through forums where information is spread, and then there are the other systems that I've mentioned.
Mr. Van Eerden, you're not answering my question. Does the answering affidavit give any details about resource constraints in expanding the system? Nobody is saying that online should be got rid of. The argument is it must be supplemented. And all I'm asking you is whether in the papers your client deals with the resource requirements that make it outside of its available resources to expand the system. Is there anywhere in the papers, perhaps your junior can look and you can tell us at the end?
If you will just bear with me for a moment. Okay. We'll revert on that issue. In orders 3 and 4 are relevant to the verification stage that dealt with the test of insufficient means and what constitutes income and what constitutes financial support in the Regulation 1. The court ruled that its interpretation thereof should henceforth apply. We deal with that in our main heads in paragraph 53 to 64. Our submission is that the COVID-19 SRD is aimed to provide temporary relief for those with insufficient means on a strictly month-to-month basis. Given government's limited resources, only those who truly have insufficient means qualify for this SRD. We submit that the regulations clearly do not exclude ad hoc income or financial support. That is why all ad hoc income, such as gifts and the like, received from family members are included in income and financial support. Orders 5 and 6 are also relevant to the verification stage. Their Regulation 23C relating to the proxy means test was declared unconstitutional and invalid to the extent that they make provision for checks against databases and may indicate income or alternative financial assistance and verification of insufficient means with banks. Our main heads, paragraph 65 to 82, deal with that. The purpose of bank verification is that the first and second appellants get the most current and reliable information so that only those that qualify as of insufficient means may receive the SRD. The verification is done monthly and it remains the effective and best method to achieve government's purpose, which is to immediately reach individuals who have insufficient means and are in need of temporary assistance, i.e. for a month at a time. The reference is volume 6, page 1094, paragraph 106, 107, 108, 109, 113, and 116.
That data is not always unique. For instance, it cannot be seen on a bank account whether or not the money...
Ek kan jy, ek kan jy talk loud.
Can't you hear? Can you hear now? Okay. Mr. Van Heerden, that type of verification also has shortcomings. For instance, where a bank account doesn't show that money is held on behalf of somebody else. Now, you've heard what I asked Mr. Marcus. Is the solution there not to allow evidence on the internal account?
I'm coming to the issue of new evidence in the appeal process. But that is certainly an instance of where one should consider new evidence. If you're dealing with 15 million applicants, there unfortunately will be cases that are so far removed that they are difficult to accommodate in a system.
No, I accept that. But is it a solution to an extent already that the appeal process must allow for new evidence?
Yes. I'll show you, Justice Mayer, that new evidence are in fact considered in the appeal process. The court quo, we respectfully submit, misunderstood that process. I'm going to come to the...
We don't find that in the regulations. We don't find that in the regulations.
No, but you find it in the answering affidavits. And I'll give you the references. I'll give you the references to that.
Okay,
So we are still at the, Mr. Van Eerden, whilst we're still on the, what are we doing now? The income and financial support.
On 23C,
yes,
proxy means testing.
yes, and that's
In relation to orders 3 and 4.
5 and 6.
I'm busy with 5 and 6 at the moment.
Okay. So I just want to go back now then to the data verification, right? And the bank, the bank verification and the data verification. So if I receive my SRD at the post office, right? And I don't have a bank account, how does that verification process work?
I cannot explain how that specific verification process will work, but what I can explain is that the beneficiary can pick the method that he wants to receive the money in. So they are in the main two. So either goes into a bank account or it's a cash send that goes to a cell phone.
No, I understand
That, but how does SASA verify that I'm not receiving other income if it cannot go by way of the bank verification method?
Well, if the beneficiary is not registered with the bank, they will be left only with other databases.
So
Now having the other databases, the respondents say that the appellants have, the DSD, have also confirmed that there has been exclusive errors, a lot of exclusive errors that have come to the fore, and hence they are saying that that data verification process is not accurate at all.
The databases are as accurate as they can be. When a beneficiary is turned away because of information on a database, that reason is provided to the beneficiary. So if there's a problem with a surname, for instance, the person is told that is the reason, and that beneficiary can then attend to the rectification of the database.
I understand why you're saying it's as best as it can be. So if the data makes an error and then I do not get my grant, so be it. The answer is it's as best as it can be.
It's not so. It's not that the beneficiary is then pushed away from SRD. There are many instances where the beneficiary has not updated personal information. So, for instance, on UIF it will show that the person is working, whereas the person is not working. If surnames seem to be a big problem as well. People married, adopt another surname, and then the doctor pick that.
So whose
Fault is that? Isn't it the data? Isn't it the database verification and not the applicant?
It is then up to the beneficiary to attend to the rectification of the database, because that is then what will enable that beneficiary to be verified against the database.
But what if the data says
Is I'm receiving unemployment, UIF, and in fact I'm not. So who must rectify that? The beneficiary.
It's for the beneficiary to approach the database owner and to have that rectified.
Isn't that another reason to expand the online so that those sorts of queries can be dealt with a person. Although I say that with caution because I don't know how many people readily get help from humans when they go into the government office. But let's leave that by the wayside. I mean, put that on the side. Isn't that another reason for the need for some human face-to-face in the process? I know I'm not addressing, orders 5 and 6 go quite far. They say that the regulation is declared unconstitutional and invalid to the extent that it makes provision for checks against databases that may indicate income or alternative. It seems to order that you can no longer use that. And that 6 says to the extent that it directs grant applicants that they are assessed according to proxy means testing consisting of verification of insufficient means with banks. That's a very stark, you may not use those databases. And because of I think they go quite far, because surely there must be some means of verification. What I'm putting to you is, I'm really linking this back to the online process only route that is followed. Wouldn't some of the other complaints of the respondents, it wouldn't go far enough for them, but at least the problems with errors, and surely those could also be dealt with more properly by adding to the online only.
Just slightly, the ideal is, of course, to improve the online system more and more.
No, I don't know if that's the ideal. I'm simply saying to add to it with some humans, beings.
And just to add to that, a hybrid system, which you have the online system,
but as my sister has put forward, a human aspect as well.
We can't decree that.
No.
But in terms of reasonableness, anyway.
Justice Keatley, the reasonableness we submit is in the application process, where I've explained how there is an outreach.
Yes, I understand.
To bring everybody in.
Do you then align with Mr. Marcus's submission?
Yes.
That verification is necessary,
Yeah.
that bank and other database verifications is necessary, and that the fact that there are errors and so on, they can be rectified, and it doesn't make those measures unreasonable. That's as I understand
As you
it.
please. I return to orders 5 and 6, where regulation 23C relating to the proxy means test was declared unconstitutional. We deal with that issue in our main heads in paragraphs 65 to 82. And I think we already made the submission that the purpose of bank verification is that DSD and SASA get the most current and the reliable information, so that only those that qualify as of insufficient means receive the SRD. We make the respectful submission that replacing the automated online verification process with a process that calls for human intervention will lead to administrative paralysis. The first and second appellants do not have the resources to process 15 million applications per month, other than through a fully automated online system. The verification methodology is reasonable and rational, and if the court orders should stand, the existing payment system will come to a halt. The SRD program will have to be redesigned. It's designed on an online-only system. We rely on two authorities for this proposition. Joseph v. City of Johannesburg, 2010-4, paragraph 29. The spectre of administrative paralysis is a legitimate concern, and courts must be vigilant not to impose unduly onerous administrative burdens on the state. And Grootboom, paragraph 41, which explains that there may be more than one reasonable manner in which the state can meet its obligations. But once the methodology adopted by the state is found to be reasonable, then that requirement is met. Orders 7 and 8 declare Regulation 6C unconstitutional and invalid to the extent that it precludes unsuccessful applicants from relying on new evidence or information on appeal. We submit that those orders were based on a misconception of the appeals process. That appeals process is set out in Volume 6, page 1099, paragraph 128 and further.
And sorry?
It's Volume 6, page 1099, paragraph 128 and further. First, unsuccessful applicants are automatically advised of the reasons for rejection. That's paragraph 129. So the process is transparent. Then we submit that knowing the reason for rejection, an applicant can update his or her personal information on the relevant database with the correct information, such as the new surname or employment status. That is paragraph 131. They are allowed to update their personal details even after the rejection. And this is where the process allows for new evidence. That is paragraph 135 and 136. So these unsuccessful applicants are afforded the opportunity to remove the obstacle and the rejection of the applications. The appeal tribunal verifies and validates the information obtained of the appellant against the latest and updated information received from the database resources to determine whether the appellant did qualify. If taking this new and accurate information into account,
This is not what paragraphs 125. What it says here is to the extent that reasons are furnished for rejection, then the applicant can have the database updated, and then the appeal tribunal will look at the updated database. The question that I posed to you was earlier on, was that why isn't new evidence allowed? Then an applicant can go and tell that tribunal this and this and this. Because not everybody will be able to go and remedy wrong databases.
To deal with an appeal process that's not automated will mean employees of SASSA will have to consider affidavits, consider bank statements, investigate that. If you have an online process where you have to, in a month, in a speedy manner, verify 15 million applications. It's just not doable.
But there are not 50 million in appeals.
Once the system is amended from online to hybrid, one doesn't know what will happen.
But even if this is now done online, not by the amendment of data. Online object because that is not correct, and then it is up to them to check whether or not that is correct.
Yes, it is up to them, up to the unsuccessful beneficiaries.
No, then it is up to the SASA officials. Not all the unsuccessful beneficiaries will be able to do that.
There might be There might be
of here, the SRD grant and its implementation. And they have egregiously failed to do so. There's a further major concern with the answering affidavit put up by DSD. It's deposed to not by the minister nor even by the DG, but by the Chief Director of Legal Services. And the contents of that affidavit appear to reflect that that deponent has, seek appropriate language, has limited understanding of the SRD grant and limited knowledge of it. Because that answering affidavit contains a number of absolutely glaring legal errors.
Okay, Mr. Brickiel, we actually even went over, but anyway, your uninterrupted time is now
As the court pleases, Justice Hughes.
over.
The legal errors, and we just give some examples. First, at a level of pleading, DSD in its answering affidavit provides a number of bold denials, including of some of its own data, of Stats SA's reports. It even denies that there's an unemployment crisis. There's simply reactive, bold denials to a number of material averments. But in terms of legal errors, that answering affidavit states repeatedly that the SRD grant is a grant for people with no income at all, with a R0 income. The language is no income at all. That refrain is repeated around 5 times in the affidavit. Central issues in this matter are the reasonableness of the means test, the definition of insufficient means, which includes income and financial support, the fact that the deponent could state repeatedly under oath that this is a grant for people with no income is a matter of grave concern. The second goes even further. And with respect, it is arguably conclusive of the review already on its own, because the deponent to the affidavit on behalf of the Department of Social Development states that National Treasury on its own makes the decision to set the value of the grant, the 350, currently 370 rand. Again, that is stated around 5 times. Provide just one reference, which is absolutely explicit. The same thing is repeated over and over. And this is DSD's answering affidavit, volume 6, page 1163, paragraph 294.2, in which the deponent to the answering affidavit states that the grant value of 350 rand is a decision solely taken by National Treasury. Bearing in mind that these are regulations promulgated by the Minister of Social Development, yes, with the concurrence of the Minister of Finance.
Well, the Minister of Finance holds the purse in any event.
Indeed so, Justice Hughes, and we absolutely accept that the Minister of Social Development is required to consult with the Minister of Finance and ultimately to secure concurrence, agreement on the regulations. But the decision is that of the Minister of Social Development. And with respect, Justice Hughes, there are deeper constitutional reasons why that is so. And this goes to, and this is the point to which I was now moving, and the stance and conduct of the 2 sets of appellants. Let me mention now National Treasury's approach in its answering affidavit. It begins at the commencement of that affidavit by saying, of course, National Treasury can only speak for National Treasury and not for the whole of government. However, as the affidavit goes on, National Treasury begins to do precisely that, and expressly to say that National Treasury and the whole of government oppose the relief, oppose what is proposed by the current respondents, that it's government's policy, that social assistance cannot go further. And this is where the actual evidence of what DSD and Treasury have said and done publicly and in relationship with each other is absolutely crucial and decisive. We have put up in the founding papers and deal with it in our heads of argument the series of policy statements regarding the nature of the SRD, its relationship to government social assistance plans, that it is the foundation of government's plan to provide social assistance to working age adults. And I don't intend to repeat those. There are 3 more specific documents that really sharply expose the actual positions outside this litigation, outside what is said in this court, of DSD and Treasury. And I begin with a presentation that DSD made to civil society in 2023. It appears at volume 6. Sorry, I beg your pardon, volume 8 in the slide. Volume 8.
I think we've been dealing with volume 6 too much.
Yeah.
So we're going to volume 8. Right.
Yes, that is so. Volume 8, page 1457.
1457. Yes, we're there.
This is a progress report presented by the Department of Social Development to civil society on 24 July 2023. It was made just after the application was launched, which is why it's attached to the replying affidavit. And it deals with it essentially provides civil society, and my learned friend has referred to this, the engagements between the department and civil society, which occurred on a regular basis. It provides an update on what was happening at that stage, mid-2023, with the grant. And I would refer to a couple of key aspects. The first on page 1460.
So we go to 1460.
1460 under paragraph 2, contextual background. And this goes to DSD. Recall that DSD and Minister are the government department responsible for creating the grant. They refer to the COVID-19 context, that it was originally created as a temporary measure to respond to the COVID-induced humanitarian crisis. They go on to state, in recognition of the prevailing conditions of ongoing vulnerability to hunger and distress among the unemployed, the grant was intermittently extended, with the latest extension due to expire on 31 March 2024. And then crucially, in relation to the impact, the grant has been shown by multiple studies to be well targeted and successful in reducing hunger, poverty and inequality, while also improving the participation of beneficiaries in job search and other economic participation, something that the President himself has said on a number of occasions. The grant has proved to be one of government's most effective anti-poverty instruments to date. So this is DSD's understanding of the SRD grant in mid-July 2024. That it's directed at hunger, poverty and inequality, and that it's been significantly effective in addressing hunger and poverty. There are then updates provided in relation to statistics, provincial, age cohorts. I don't intend to refer the court to those. They don't concern any issue in the appeal. But at 1466, DSD's proposals. Now these are the proposals that DSD is sharing at that stage with civil society, but making publicly. These are its proposals for the SRD grant for the next 2 years to follow. We're in mid-July 2023. These are the proposals for going up to 2026. They begin by recording that National Treasury allocated 35.7 billion to the SRD grant for the year 2023 to 24. They then record that the current amount of 350 has not been adjusted to keep pace with inflation since the introduction of the grant in 2020. In real terms, this implies a decrease in the grant value individuals are receiving of around 16%, increasing the grant to 500 Rand or 663 Rand a month would have a significant effect on poverty. There's then a reference to the ongoing vulnerability of beneficiaries to hunger and poverty as a result of continuing high unemployment and the escalating food prices. The department is proposing the extension of the CSRD until the end of 2025-2026, while policy work is underway to finalize a more permanent income support policy. We're proposing a 2-year extension at that stage. And then crucially, these are their specific recommendations at the foot of the page. The department therefore recommends the following: extending the allocation for the SRD grant for the next 2 financial years, increasing the amount of the grant from 350 Rand, increasing the current means test threshold from 624 Rand. They then provide a detailed rationale for the extension of the grant in the page that follows, 1467. And we emphasize the second bullet point, DSD's understanding of the factual position. Latest estimates suggest that roughly a quarter of the South African population, 15 million individuals, live below the food poverty line of 663 rand. That was the value of the food poverty line in 2023. Without enough income to buy a basic basket of food items necessary for survival. We further refer over the page, 1469, to the rationale for increasing the amount. So that previous section dealt with the rationale for extending the period of the grant. The essence of it is that the underlying social conditions demand it, as understood in terms of the Constitution. But they provide a further rationale for why the amounts need to be increased. And DSD records, they refer to high levels of inflation, ever-increasing cost of living, and say that it's imperative that government continue to provide immediate assistance to avert severe hunger and deprivation among unemployed adults in the country. In the next second bullet point, DSD records that since the grant has been kept at 350 Rand since 2020, its real value has declined to 282 Rand in 2023 prices. This represents a significant decline in the purchasing power of the grant, from around 11 Rand per day to 9 Rand per day in real terms. The department therefore proposes an increase in the value of the grant to 663 Rand, which is the latest food poverty line published by Stats SA. It provides an alternative, though, in the next bullet point. Alternatively, the grant value should at least be increased to 500 Rand per month, to at least match the child support grant value. Although this is still not enough to buy a monthly package of adequate food for an adult, it would be an important signal to the poor that government recognizes their hardship in the face of escalating food prices and the generally steep cost of living increases. The final bullet point links this proposal to the establishment of a minimum social protection floor as outlined in the NDP Vision 2030. Over the page 1470, so we've dealt with grant value, recommendation to increase it from 350 Rand to 663 or at least 500 Rand. Over the page, the rationale for increasing the means threshold. The current means test threshold used by the department is 624 Rand, based on the previous year's food poverty line. Stats SA has since adjusted the food poverty line to 663 Rand and also adjusted the lower bound poverty line from 890 Rand to 945 Rand, and also adjusted the upper bound poverty line. Those are the three national poverty lines determined each year by Stats SA and deployed by government for a range of purposes. In the fourth bullet point, the department recommends that the means test threshold used for determining eligibility be adjusted in line with Stats SA guidance. And in the fifth bullet point line, proposes the use of the food poverty line as a means test threshold. That's what was originally adopted by government. That's where 624 Rand came from. It was the food poverty line in 2021. So the department reasons we should act consistently with that, use the food poverty line, which in 2023 was 663 Rand. Those are the department's public proposals in mid-2023.
Mr. Brickell, what's the date of these?
24 July 2023.
And okay, so it came between answers and reply? Or not? Do you know the timing? We can check the answer. I know the answering affidavit was...
Certainly after launch. Justice Keatley, the Minister of Finance filed
November
in December,
23.
so it's before the answers,
Yeah.
but not put up.
So we don't know whether these proposals went to anyone.
I'm getting there, Justice Keatley, with
All
respect.
right. That's fine.
Okay, before you get there, it's now
is
1
it late?
o'clock.
Oh, that's why you were giving me a behind.
Okay, we will then take the lunch adjournment and resume at 2.
As the court please.
All right. Yes, Mr. Brickier.
May it please the Court, Justice Hughes, Justices. Before the lunch break, I was making the submission that the Court had been left in the dark by the respondents.
Literally.
We find ourselves still in the dark, but the respondents are seeking to bring some light to the actual events that took place outside the frame of the litigation, and as appears from the record. The submission effectively is that the case has been advanced on behalf of the appellants unmoored from the papers. So not only did they not put up the material they should have, but they've also argued it without reference to the actual facts that appear from the papers. And those actual facts cast the case in a completely different light. I dealt before the break with DSD's presentation to civil society on 24 July 2023, in which it proposed that the grant be extended for 2 years, that the grant value be increased from 350 to 663, or at least 500 rand, and that the threshold be increased, the means threshold also be increased to bring it in line with the then food poverty line against which it was originally pegged. So that was the presentation to civil society, and I was asked the question by Justice Keatley, well, do we know what became of this? We do know, in part, from Annexure RA 36. This is also in Volume 8, at page 1592. This document is a National Treasury presentation to the President in Stellenbosch in 2023. It is undated, but it's clear from the content that it's happening at least after DSD has formulated the proposal, the 24 July proposal that we dealt with before the lunch adjournment. Because, as I'll indicate now, it conveys the same proposal to the President. And the relevant parts, the first part of page 1592, refers to legal challenges. That's a reference to this litigation. It then sets out in the second main bullet point in the first section, cost implications if grant extended beyond March 2024. But the crucial part is the second half of the page. COVID-19 SRD grant, which reads as follows, and I need to deal with the detail of it. The first bullet point, additional 40.5 billion in 2024-25, 46.6 billion in 2025-26, and 52.7 billion in 2026-27 required if the COVID-19 SRD grant continues beyond March 2024 at 565 Rand per month, which in brackets 350 Rand plus CPI. Okay, so what National Treasury is conveying to the President is the costing for the next 3 years if the grant is continued with an increase at CPI in each of those years. That's based on beneficiary numbers remaining the same. So Treasury have done that costing and presented it to the President. Continues, the second bullet point deals with administration costs. Those aren't really an issue in this appeal, but essentially what Treasury does there is to cost the administration costs in relation to the SRD grant for 3 years to follow, which are in the region of 400 million Rand per year. Those are the costs for SASSA to administer the grant, which must also, of course, be budgeted for and are budgeted for. The third bullet point is the crucial part. DSD are submitting a memorandum tabled below to Cabinet for, first bullet point, extension for 2 years, while BIS, that's basic income support, policy proposals, replacement is under negotiation. Second bullet point, proposing increase in grant value and income threshold, see options below. And then the third bullet point, DSD expresses a preference in the memo for the 73.2 billion Rand option, but underestimates the beneficiary growth in all options. That's Treasury's presentation to the President of DSD's proposal. And as we'll see from the table below, the 73.2 billion option is exactly what DST presented to civil society. So in the first column of the table, there are COVID, and I'm struggling a little in the light, COVID-19 SRD options. And there are 3 options to increase the value of the grant in those first 2 columns. An increase by inflation, an increase to bring it to the child support grant, or an increase to bring it to the 2022 food poverty line. And those grant value increases are set out in the second column 430 Rand, 500 Rand, and 663 Rand. And justices will recall that those are the figures that DSD proposed to civil society as the increases, the second 2 options, to bring it in line with the food poverty line, or at least the child support grant. But what's clear from the table is that DSD have also considered an inflationary increase, which would have brought it to 430 Rand. The columns that follow set out different means test thresholds, so if those are adjusted from 624 Rand. The first one set, and so to explain it, the first row sets out the proposed new threshold. The second, the estimate of the number of beneficiaries that would result in, the total number. So for illustration, the first column is 663, so that's if it were increased, the threshold were increased from 624 to 663, the number of beneficiaries would be 8.5 million. That's the same as the existing number of beneficiaries, for a very obvious reason. It's just tracking the food poverty line on which the threshold was previously set. Then there are possibilities for raising the threshold higher to 945 Rand or 1,417 Rand, and what that would mean for the number of beneficiaries, 9.2 million, 12.2, 17.5. And the Treasury preferred option, if the court is with me, is to raise the threshold to 945 Rand and to raise the grant value to the food poverty line of 663, which is the bottom row and 3 columns along, which takes you to the 73.2 billion costing that DSD has performed. That is the total cost of paying the grant at the increased value of 663 Rand to a projected 9.2 million beneficiaries. And that comes to 73.2 billion. And we know from the presentation that DSD has presented this proposal to Cabinet in the form of a memorandum. Or rather, we know that DSD were submitting a memorandum, so Treasury understood DSD to be bringing this to Cabinet.
Okay, so this annexure says 2023, and you're saying it would have been after the November 2023 presentation.
It at least has to, Justice Hughes, we don't know the date of the presentation from the affidavit or the document itself. It must at least logically have been after DSD developed that proposal. They may have presented to the President before civil society, but they had at least developed the exact same proposal. Extend for 2 years, raise the value of the grant to 663 Rand, raise the threshold to 945 Rand.
So we know that's what DSD, that's what DSD proposed.
It's what DSD proposed.
Yeah. And that was included in a presentation by Treasury to the President. And then we don't know anything
And then
else.
There are a few more chapters to the story,
okay.
Justice Keating.
Oh, from the desk of the President and so on. Yeah, okay.
For completeness, Justices, the following page of the presentation, and I won't deal with it in detail, sets out Treasury's possible sources of funding to fund what DSD has proposed. And It presents these as closure of other programs, a VAT increase, alternatively extended for a year. Now, Treasury will submit that these were the only realistic ways to fund DSD's proposal. But as I'll demonstrate in a moment, all of the evidence confirms that that is not so. For now, I'm making the point is a more focused one. DSD's view is that the grant needed to be extended, the grant value needed to be increased, and the threshold needed to be increased in order to realize the constitutional right. DSD had costed this, determined it, set out a range of options. And I reiterate that none of this was placed before the court by DSD or Treasury.
What in the court of co?
Yes.
But was this not a document intended for discussion in cabinet? And I would imagine that in such a situation, the question of affordability would then come to the fore. It's all very well for DSD to have those lofty ideas that this is the ideal situation, and then Treasury was costly and determine whether it would be affordable for the country as a result of all the other demands on the fiscals.
Justice Petse, I think there were two parts perhaps to your question. The first part is really whether this ought to have been placed before the court. And the second is the appropriateness of Treasury's role. And if I can deal with them in two parts. The first part is that in Mazibuko, the Constitutional Court tells us that in a matter of this sort, relating to progressive realization, the state has to play open cards with the court. It needs to share its research, investigation. It needs at least to share what the relevant line department has proposed should be done. And that is not even placed before the court. Instead, Treasury purports to speak for government as a whole. And we'll demonstrate that we'll submit that is constitutionally inappropriate. And that's the second part of your question, which, if I may, I'll develop a response in a moment. There are two further documents which tell a further part of the story, because what we've seen so far is DSD's proposal and that it goes to the President. There are also interactions on the papers between DSD and Treasury, and around the concurrence in the regulations and the setting of the grant value. And in essence, if I can headline what those show, is that DSD was seeking to increase the grant value and Treasury was vetoing and blocking those proposals and withholding concurrence on the regulations. And I'll provide the relevant references. And in fact, I must take you to one of them. It's a crucial document. So this is in volume 2, page 319.
Mr. Brickell, isn't that Treasury's function?
Justice
Keatley, I'm not talking about specifics here. That's why I'm not waiting for you to take us there. But you can hardly say that Treasury was acting outside of its remit by considering the wish list of DSD and considering financing options or funding options, and what funding options were available and what would make most sense. I'm sure you aren't suggesting that that wasn't part of Treasury's function.
Justice Keatley, and this is the concern that question that Justice Petse put to me too, or it relates to it. We absolutely accept that Treasury has a constitutional role to provide input on the affordability of programs to the substantive departments responsible for delivering social rights and other government programs. But this is where it oversteps, and this is the real separation of powers dimension to this case, because the case has been argued on behalf of the appellants using the usual separation of powers refrain. It's not court's job to determine social rights. It's not court's jobs to make orders with budgetary implications. It's not courts' jobs to give precise content to rights. Deference, expertise, polycentricity, that's how it's been argued. But the real separation of powers situation that these facts unearth, and the next document really exposes it very sharply, is that Treasury is purporting to determine the content of constitutional rights, overriding the substantive policy-making powers of the Department of Social Development and the Minister of Social Development. It is the Minister of Social Development who is enjoined under the Social Assistance Act to make regulations establishing an SRD and other grants. It is the Minister and the Department who have the expertise and, frankly, as we see, the commitment to the Constitution.
The expertise might be there, but they have to be funded.
Indeed, Justice Petzer. They do.
So if there are no funds available for what DSD had proposed, and as my sister quoted to you, presented their wish list, that wish list must be funded.
Indeed, Justice Petzer. We accept that as a constitutional principle. On the facts, it doesn't hold. And I'll develop, but let me headline it because it's clearly a concern of the court. The grant was underspent every single year. The original allocation was 44 billion to the SRD grant. The case of the respondents is that it's all of the other unlawful barriers that push beneficiary numbers down and meant that every single year the grant was underspent. That's the first key fact on affordability. The second is the increase that was given, the 20 Rand increase in 2024. And the sequence of that is important. Treasury delivers its answering affidavit. If I can summarize its answering affidavit, the SRD grant as a whole is not a good policy option. Growth is better. The SRD grant is not affordable at all, and no increase to the SRD grant is affordable. Not 1 cent. Less than a year later, a 20 Rand increase is introduced for every beneficiary. My learned friend described it, I think, as modest. That 20 Rand increase is a 5.7% increase. It's close to inflation. It makes an enormous difference in the lives of beneficiaries. That kind of scale of increase every year. It's the difference between eating or not eating on one day or another.
Mr. Brickell, just if I could go back to your separation of powers starting point.
Yes.
And I realise you've gone to 2 facts and you're going to give us more, so I'm sorry I'm taking you back before you finish that. It was when it comes to socioeconomic rights, those are always to be, the obligation depends on available resources. And I mean, obviously it says so. I'm not telling you anything you don't know. And my question really is, in that scenario, just explain to me how Treasury's intervention, and I don't mean that in any loaded term, how that constitutes an unlawful intrusion into the powers of DSD. Because at the end of the day, it's Treasury that determines most closely, is the Department of Government most closely associated with overall resources, not only resources to DSD, but overall resources and how those are allocated and so on, to put before Parliament, obviously, for Parliament then to accept or reject. So are you saying in this particular case, because of the facts that you are setting out, there was an overstepping? You're not suggesting that Treasury wasn't permitted to make resource determinations in terms of budget, or in withholding its concurrence. It could withhold its concurrence as a general principle. Would you accept that?
Justice Keatley, lawfully so. And the document...
I'm saying in principle, in principle, obviously it would have to be lawful, but that would depend on the facts, which is where I'm asking you. So it could refuse to concur with a wish list from DSD or any other department, so to speak.
Justice Keatley, with respect, not if that resulted in a breach of constitutional rights, not if it was unconstitutional.
That's why I'm asking you to say in principle it could. Are you saying in this case,
Indeed,
because of how
yes.
it did so? Is that your argument?
Justice Keatley, if I can answer it at three levels. And first, if I can headline it, the headline response is, we are a constitutional supremacy, not a fiscal supremacy.
No, okay, I
Treasury
think
is
that's obvious,
subject to
Mr. Brickell.
three levels, Justice Keatley. The first, DSD in its answering affidavit says entirely incorrectly in law, National Treasury determines the 350 Rand value of the grant, solely. National Treasury solely. And then if I can answer with this analogy to health or education, because it may be that the fact that a grant takes cash form intuitively leads us to lend more authority to Treasury's role. It could never be suggested that it would be for Treasury to suggest what a hospital should look like, how many we should have, what medication should be provided, how many schools should be provided, or any. So it has an important constitutional role in addressing affordability and placing that within the government's overall decision-making processes. But the primary government actor responsible for giving content to the right to social assistance is not Treasury. It's the Minister of Social Development.
I understand that. I understand the point you are making. But I'm specifically focusing on the fact that we are dealing with a socioeconomic right. The constitutional obligation to provide it progressively is within available resources. And for all of these social grants, including this one, Treasury has to concur. Okay. So I'm saying in those situations, it's actually very simple. I'm just wanting to know where your argument goes. Are you saying that in this case, because of facts A, B, C, or D, I sound like the Madlanga Commission now, if anyone watched yesterday. There were lots of A, B, C's, and D's. But, because of these facts, and this is what happened, in these circumstances, it overstepped. So is it fact-based? Or is it, I understand your general proposition, that I understand.
Yes.
Are you saying that in this case, the facts show that there was a breach of an overstepping into? Is that really where you go?
Justice Keatley, yes on the facts. And in particular because of DSD's position. This is different to a case where civil society or rights bearers challenge the underlying policy decision. What the respondents actually seek to do is to give effect to DSD's policy preferences.
No matter what.
Justice Petzin, not no matter what. So this is perhaps the second, with respect. This is the second part. The order only seeks a plan which would be multi-year, phased in to progressively realize the right, subject to affordability. We have always accepted that affordability constrains it, that it's a relevant consideration in whatever plan needs to be adopted to progressively realize the grant value and the means threshold. It must be subject to affordability. But Treasury's position in this case is that no increase of whatever amount is affordable or will be considered, and no plan will be adopted. That's the position on the papers. DSD's proposals, as we've seen, to civil society, to the President, to Treasury itself, extend the grant, phase in gradual multi-year increases. And perhaps this is where we accept that there may be some compromise to be reached between DSD and Treasury, with the President playing a leadership role, government as a whole. But what has effectively happened is that it has been frozen in place, static, and we submit that that is also a retrogression and a failure to progressively realize the right. If I may then take the court to Annexure FA 37. It's in Volume 2, page 319. I'm struggling a little with light.
Your job is to make us see the light.
Yes.
So this is an annexure to the founding affidavit. The document is admitted by all of the appellants.
I'm
but
so
not,
sorry, what was that?
Volume 2, page 319.
319.
And this document really sheds light on the relationship between DSD and Treasury. It is a...
319.
Page 319 of Volume 2, Justice Petzer. This document is a briefing document from the Department of Social Development to their minister, at the time Lindiwe Zulu. The document is unfortunately again not dated, but it's clear from the content that it is a memorandum relating to what are about to be implemented as the 2022 regulations, the regulations that are under challenge, although that have been amended many times. And it is dealing with the process of the promulgation of those regulations, including the concurrence of the Minister of Finance. And there are specific aspects that I'll draw the Court's attention to with respect in the interests of time. From page 321, in paragraph 2.3, it deals with concurrence and the issue, Justice Keatley, that you put to me with respect. It's the facts on that issue. The Minister of Finance needs to concur with the regulations. Currently, we have regulations that the Minister sent to the Minister of Finance in November 2021, to which we still have not received a response. And crucially, 2.3.2, every effort will be made to engage with National Treasury on the regulations. However, this may not yield any results due to their unfavourable views towards the SRD grant. And the next paragraph. The National Treasury has made a number of unreasonable requests for conditions on the grant, on this grant. We may run the risk that they may just withhold concurrence if we do not accede to these. Justice Keatley. 2.3.3.1. The DG has written to the National Treasury explaining the difficulties and even the constitutional implications of some of the conditions they require. Finally, we may also need to consider the publication of the regulations without Minister of Finance concurrence. So this is the position the department found itself in. That letter that the DG wrote to the Minister of Finance has not been provided to the court. In fact, we're not even told about any of those interactions by the appellants. If I continue, then there are a few other crucial aspects. 2.5 deals with the budget. On page 322, an insufficient budget was allocated for the SRD grant, in the view of the Department of Social Development. An amount of 44 billion was allocated for 10.5 million people. The letter we sent to National Treasury indicated that we would require a budget of between 56 and 75 billion per year for the extension of the SRD grant. We are already at 10.45 million in January and likely to pass the 10.5 million mark in February. And if I turn over the page, this relates to the budget cap, and there was debate about this earlier. Justice Petze asked the question, well, it never happened, did it really arise, that the budget cap was implicated? Here is DSD in 2.5.7, saying, should no additional money be allocated, we may have to suspend the grant in month 9, depending on how fast the grant uptake increases. There are other relevant parts, but I'll just emphasize the most salient. On page 324, paragraph 2.7.6, dealing with the grant value. There may be a general societal dissatisfaction due to the regulations not making any progress in terms of the calls for a higher value for the grant and ensuring less people are excluded. The essence of this case. From the allocation, 2.7.6, Justice Keatley, on 324.
Thank you, got it.
And then finally, the following paragraph, from the allocation, no room is provided to reach more people or increase the value of the grant. Okay, so that's DSD's briefing to their own minister. referring to Treasury's unfavourable attitude towards the SRD grant specifically, and that it has sought to impose unreasonable conditions, in the language of DSD, which may have constitutional implications. If I can provide one...
Who was the author of this? Do we know? Is it the DG?
It's only indicated as the department. Again, it was put up in founding papers. The document is admitted by all of the appellants, but no explanation provided.
Do we know if the minister, is there any, oh, I'm so sorry.
So we need only concern ourselves with the fact that the document, as you say, was put up in the founding affidavit admitted by the respondents. It's a departmental document, there's no dispute about that.
The document is admitted, Justice Petse, yes. What we do know is that in parallel there was an exchange of correspondence between Minister Zulu and Minister of Finance Godongwana. And that appears in volume 8, page 1452. And in essence, I'll summarize it. I don't have time to deal with it, but in essence, it's Minister Zulu pleading for the Minister of Finance to concur, saying that we've been waiting. It also raises the matter of needing to resolve bank contracts for the bank verification process. And it has an interesting paragraph in which Minister Zulu says, in my view, I may not even require your concurrence when I determine the grant value and the means threshold. Now that may go too far in terms of not requiring concurrence, the question that Justice Keatley put to me. But we would submit that Minister Zulu is absolutely correct that it's primarily her decision, taking into account affordability, what the grant value and the threshold should be. It's not a decision for National Treasury, certainly not a decision solely for National Treasury in the language of DSD.
Mr. Brickell, if the minister did that and regulated the grant value, because that's how it's done, by regulation, what would the fiscal implications be? I'm
getting to that, Justice Keatley, imminently, and I'm aware that it's a concern of Justice Petse also. If I may provide just one further reference, most of these are in our heads in terms of it being temporary and the attitudes of the various ministers. We have Minister Zulu speaking in Parliament, talking about her desire to increase the value and that she's working with the Minister of Finance to that effect. We also have the Minister of Finance, and this is the reference I'll provide, volume 2, page 370. 368 is Minister Zulu in Parliament saying, I want to increase the value and I'm working with the Minister of Finance. 370 is the Minister of Finance saying, we are under no illusion that we can simply drop the SRD grant without a fundamental replacement, in response to parliamentary question. I've dealt with these exchanges to demonstrate that the position advanced by the appellants in argument is inconsistent, certainly in DSD's case, with its actual position, substantively. The views that it has taken on what is required to realize the constitutional right and what is reasonably appropriate in the circumstances. Those appear clearly from DSD's presentations.
Perhaps to a certain extent, because, one must between two situations where you have a proposal as a department which requires to be funded by a sister department, and you present what your ideal situation is. It goes back to what I raised with you earlier about the question of affordability.
Yes. Justice Petse, and we absolutely accept that affordability is a material consideration in deciding what the Constitution requires. But the overall inquiry is what the Constitution requires, with affordability being one important constraint on that. And it may mean that the increases are lower or more gradual than DSD or the respondents in this matter would wish for. but it doesn't entitle National Treasury to shut down the process entirely and say there will be no plan, no increases will be considered at any point, especially where DSD has said this is what the constitutional right requires. To address hunger and poverty of 15 million people, this is what we're required to do. And DSD, I'll make one further submission. DSD is making this proposal alongside all of the other proposals that it makes for every other social grant. It's not making it in the abstract. DSD makes similar proposals for every other grant. And that brings me to two of...
Just before you go to where you went, the issue of Treasury wanting to shut down the grant, that can't be true, because you have just advanced that when you read one of the documents, that Treasury acknowledged that there is no way that they can just shut down the grant without replacement.
Yes. I'm distinguishing two things, Justice Hughes. The Minister's public statements and their stance in the litigation. Their stance in the litigation is to block any increases, any plan, any scope for any plan to increase the grant value or the threshold. They resist that absolutely and steadfastly. And that is all that the order of the High Court set in motion. What DSD and government as a whole is constitutionally required to do anyway for every socioeconomic right. Make a plan to progressively realize that right over time.
Well, the respondents say that they're blocking every move that careers towards the increasing of the grant and the threshold. But they come at the response and they say, our hands are tied because of the fiscus.
Yes, they do. They are wrong, in fact, Justice Hughes, and let me deal with that. I'll return to the SRD grant is not a social grant. With respect, that argument is meritless and it's contrary to their pleaded case. Let me deal with budget and affordability.
Yes.
The starting point is that no part of the order touches the budget. No part of the order directs Treasury to budget a specific amount, or government to budget or allocate a specific amount, contrary to other decisions, and I'll deal with Adonisi in a moment, which expressly directs budgetary relief. The relief is limited to a plan to progressively realize the right, taking into account relevant considerations. So, ultimately, this is not an issue that the court may need to decide. What is affordable, how much should be spent, or how much could be spent. Treasury's position is that nothing is affordable. No increase can even be considered. The grant itself is unaffordable, and any increase of whatever amount would be unaffordable, whether to the grant value or any increase that increased the number of beneficiaries. They advance their case by multiplying and putting up what we submit as a straw man, the biggest possible impact of all of the relief being granted. So if DSD got its wish list overnight and was able to increase the grant value to the highest amount and the threshold to the highest amount, that would result in additional expenditure of the 93 or 139 billion. That's what they put before you. And they place those big numbers we submit before the court, as they did in the High Court, in terrorem, because they are significant sums. But what they failed to do is to place them in perspective. And with respect that we've been debating Treasury's role, that is its role. If we're talking about affordability, we can only think about that in the context of the budget as a whole and the social assistance budget specifically. And that, one further submission on that score, the defense that they advance, nothing is affordable, the SRD grant is not affordable, no increase is affordable, could be applied boilerplate to any other government program. Health, education, pit toilets, doctor vacancies, it could be copied and pasted and applied. It's not specific to the social assistance budget or the budget as a whole. So let me come to that. And this, we know that this is the correct inquiry because Justice Mokoro for the court in Kosa at paragraph 62 conducted this very inquiry. What will the additional costs be? and what proportion of the social assistance budget do they constitute? In that case, it was concerned with adding permanent residents into social assistance, and in paragraph 62, Justice Mokgoro does the calculations, and the additional cost would have been approaching 2% of the social assistance budget. And Justice Mokgoro holds that that is not unaffordable, and in the context, it's unreasonable to exclude permanent residents. She strikes down the legislation. So what facts do we have here? And we've submitted that all Treasury does is put up these big total numbers. If everything happened overnight, this is potentially what it would cost. What we do have is the 20 Rand increase that Treasury itself implemented or decided, seemingly solely again, in 2024. That 20 Rand increase, and the numbers are a little easier. We've got 8.5 billion beneficiaries, but for the sake of argument, I'm going to take 10 million beneficiaries. Let's say even the beneficiary numbers had increased. They didn't. They stayed at 8.5 million. But the number is easier with 10. If it's 10 million beneficiaries, that 20 Rand increase costs 2 billion Rand for the year. That was the cost of that increase. In fact, it was less. It was 1.7 billion because there were 8.5 million beneficiaries. 8.5 million times 20 Rand per month for the entire year takes you to 1.7 billion. So what proportion, applying Justice Mokgoro's methodology in paragraph 62 of COSA, what proportion of the social assistance budget is that? Well, at the relevant time, it's now considerably higher. I'll come to the budget speech in a moment, but nothing turns on it. At the relevant time, the social assistance budget was over 250 billion Rand for the year. That 2 billion Rand is well below 1% of the social assistance budget. So if we step back, National Treasury says nothing is affordable, no increase, nothing is affordable, then implements a 20 Rand increase, which it explains as the reweighting of priorities. That cost less than 2 billion Rand, which is far below 1%. It's actually closer to 0.6% of the social assistance budget, and of the total budget, it's less than 0.1% of the country's budget. So that was the increase that they did implement. That is a central part of this case, that grant beneficiaries seek incremental increases of that sort of proportion, close to inflation. That 20 Rand increase was close to inflation, but not tied to inflation. We've never sought to be prescriptive. But the question is affordability, and we submit that on the facts, that was clearly affordable, on Treasury's own version and on the facts that are before this court. Of course, we emphasize again that the order doesn't dictate exactly what the next increases should be, and affordability will weigh on them. But it cannot be said on the papers that no increase whatsoever at any point in the future is unaffordable. Sorry, Justice Keatley.
The founding affidavit, if the stance you took in the founding affidavit were to be followed through, your clients wouldn't say that the 20 Rand was any form of progress at all on the case you made out in the founding affidavit. I'm speaking quite simplistically.
I'm following Justice Keatley.
And so I'm struggling a little bit for the stance you reach by the end, where you are now, to say because there was a 20 Rand increase, that is really what your clients are looking, well, not your clients, but the people whose interests they advocate, or your clients, are looking for. Because the case made out in the founding affidavit was very much, should be in line with at least one of the poverty line measures, at least should be in keeping with inflation, and that really is what is needed within a reasonable space of time, I suppose, although I don't know if that was stated. But I mean, the 20 Rand wouldn't have been seen as any form of meeting the case you made out in the founding affidavit. And now it does seem that the case is, this is really what we wanted. Any small thing will do, and that proves our case that there is funding.
Justice Keatley, with
I understand I'm putting it simplistically, but you do understand a bit my dilemma.
I understand clearly your question, Justice Keatley, but with respect, that is the construction of our case that the appellants have sought to put on it. We have never been prescriptive about the amount of the grant value. The order doesn't do it, but nor did the founding affidavit. What it put was that the value had fallen, there had been a retrogression. So there are two aspects. We sought relief that would remedy the retrogression, but without being prescriptive. So there'd been no increases for 3 years. Remedy the retrogression. Actually, that 20 Rand increase is close to inflationary. We also didn't tie ourselves to inflation. We have never sought to be prescriptive, nor does the order do so. It posits that the relevant considerations are increases in inflation, increases in the cost of living, increases in the national poverty lines, including the food poverty line. Our clients have advocated, and perhaps this is what you may be referring to, Justice Keatley, in their advocacy space in some of the annexures, have called for the value to aspire to reaching the food poverty line and ultimately the upper bound poverty line, exactly the same as DSD has. DSD has also called for those. But our case has never been tied to inflation. And Justice Keatley, that 20 Rand...
I wasn't meaning inflation, I wasn't focusing on inflation.
It has not been prescriptive in any respect. It has sought...
Yes. Hear me out. And I know your time is short. So the substance of your case has been the failure to reach the poverty lines or even come close. And that really is the kind of social assistance that should be given, because this,
Yes.
I understand your order, but your order isn't, you say it's not prescriptive, but what it does require is government should take into account real-term value of the grant in light of inflation and cost of living.
Yes.
And the value of the grant in relation to objective income poverty measures, including... So you framed it in very broad terms, but I think... So if Treasury and DSD put forward regulations that fell far short of this, and they say, but we did consider it, but it's not affordable at the moment, would that be complying with the order or not?
It may well be, Justice Keatley, and perhaps I can answer in this way and clarify. The founding affidavit sought to give content to the full realization of the right. The full realization of the right would tie the value of the grant to one of the national poverty lines. And DSD takes that view too in the presentations that I've referred to earlier. What the case has never sought to do is to prescribe that value needs to be reached immediately or at any point. We accept that the obligation of the state is to progressively realize within available resources that right. That may take a number of years. What they cannot do is move backwards, and that's the retrogression.
Yes, but the 20 Rand would be moving forward.
Yes.
Do you accept that?
It was celebrated, Justice Keatley.
Do you accept that that's a progression?
Yes.
That would meet their...
It was one of the three instances...
That would meet their obligations?
Yes. It didn't meet... We don't accept that single increase in 7 years has met their obligations. It constituted one step forward. It's the only step forward on grant value during that period. So it on its own was a step towards progressive realization, but what is required of the state is concerted, planned, phased steps towards progressively realizing, within available resources, Justice Baird said, the full realization of the right. And ultimately, this court doesn't need to decide how quickly that needs to move. The question before this court...
But how implementable is that, Mr. Brickell? You're putting an obligation on, not an obligation, a burden on courts to monitor the structural interdict and to determine whether it's moving quickly enough.
Justice
That's so. That either the remedy is prescriptive enough that a court can say yea or nay, or it's not prescriptive, it's open-ended, but then what is the point? And why burden courts with making adjudicative decisions on open-ended criteria? If you say they are open-ended, like that the appellants must give due consideration to the real term value of the grant, the value of the grant in relation to objective income. That's, if they are so open-ended that you are then simply burdening the court with oversight and having to look at reports and further litigation. So either it needs to be prescriptive, or then the remedy should be something other than a very loosely framed structural interdict.
Justice Keatley, first just one point on the order and then on the process and the role of the courts. The order does not require supervision necessarily.
Weren't you supposed to? Isn't there something that
it permits supplementation and re-enrollment, but what it envisages.
Right. No. Well, they must give a plan to the court.
But it doesn't require approval of the court, Justice Keatley.
That doesn't matter.
Justice Keatley, it's an important point with respect for the separation of powers. It makes it a deferential order that essentially leaves it to the appellants to do what DSD is trying to do.
But Mr. Brickell, it places a burden on a court to somehow, you are going to have ongoing court
not necessarily
the possibility to implement the plan without delay. I mean, that is so broad.
Justice Keatley, with respect, it is framed in very similar language to structural interdicts in other socioeconomic rights cases. They are no more prescriptive or precise than this order. The criteria that it identifies are the very criteria that DSD uses.
No, I understand
Inflation, it can barely be suggested that any of those is irrelevant.
But isn't your real case, your separation, your intrusion by Treasury into DSTs, isn't that the real case? I mean, isn't the real attack on Treasury's intrusion into DSTV, I keep saying that, I don't even watch DSTV, into DSD's sphere of constitutional obligation and power. And you know, that strikes me as being the more direct way to get what you want. I know we can't tell you how to litigate, but you know, I suppose I am thinking off the top of my head. But if your real complaint is Treasury's intrusion unlawfully, you know, then maybe it's for DSD to invoke the provisions of the Constitution that require departments to talk to each other and so on, or for someone to come in and litigate and say this is unlawful.
Justice Keatley, that is a core factual feature of this case.
Yes,
and factually, it is the cause of the blockage that has prevented DSD from discharging its constitutional obligations to plan. In terms of the relief that we seek, it is the ordinary relief in a socioeconomic rights case to develop a plan to progressively realize the right, taking into account relevant considerations. It may be, and Justice Petze has raised it with me on occasions, that affordability should be added expressly to that list as a relevant consideration. We've always said in all of the affidavits and heads that affordability is obviously a relevant consideration. We would have no difficulty with adding it to the list of considerations. Justice Keatley, there was one other aspect that I left unanswered, that these considerations are not prescriptive, that they're too open-ended. In fact, they are quite objective factors. Each one is a number. So inflation is a percentage, the food poverty lines are a rand amount. They are the considerations that DSD uses to plan for every social grant,
I understand that.
they are clear and prescriptive.
No, I understand that, but the affordability isn't. And that is, you know, that's
Even-
why it becomes looser.
Justice
Yes,
Keatley,
yeah.
the affordability...
Just before you answer, just a
Yes.
reminder so that we,
All right,
we know.
I will close my mouth now. I know when I'm...
You have up until 12:15.
Justice Hughes, I did commence at 12:25. I've had
Yes, 25 past. You commenced at what?
I've had 35 minutes and
Was it
just
not
under an hour.
12:15?
No, Justice Hughes.
Okay,
No.
so
Because remember we had the tea break, which it wasn't on the button.
okay.
Justice Hughes, I don't mean to be churlish.
No,
No,
but
With respect.
on your count,
On my count, Justice Hughes, we have 27 minutes remaining. If I'm kept to the 2 hours rather than the amount of time that the appellants took.
so that will take you to
25 past.
Yeah, I was saying 12:15, you saying 25 past. Okay.
I've been answered, Mr. Brickle.
You were going to raise
It may help
Directors to a
to
point.
deal with some of the law, which I haven't yet had the opportunity to address. There's one further aspect on the facts and affordability. First submission is that the affordability of this grant involves an assessment no different to that in relation to every other grant and every other government program. Every other substantive department and Treasury are able to work that out and determine increases each year, which are ultimately adopted not by Treasury but by Parliament when it legislates the budget. So there's nothing different. That's the first submission. But briefly on the 2026 budget speech, which National Treasury seeks to keep out of the appeal record on the basis that it needs to be tested and that it leads to disputes of fact. And it's best understood in relation to 3 levels of fact, the budget speech. The first level is the most basic. The minister gave the speech, this is what it said. They accept that. They then jump to a third level, which is the debate about affordability. They argue that that is contested and therefore the budget speech should be kept out. But we don't put up the budget speech to establish facts directly on affordability. What the budget speech does is to state very clearly what the budget is for the current year, which is 2.67 trillion rand, what the budget is for social assistance, which is 292.8 billion rand, that the SRD grant will continue in its current form, that gross tax revenue is up by 21.2 billion rand, that as a result government has cut 20 billion rand in taxes as a result of what the minister calls the improving fiscal position. So it's these very limited facts, they're identified in our application to put it up. At the very least, this court, we would submit, would be deciding the case artificially if it didn't have regard to the fact that the minister has announced that the grant will continue in its current form, what the total budget is, 2.67 trillion, and that the social assistance budget is 292.8 billion. How else can affordability be assessed other than in the context of the budget? It can't be assessed
What's your value to the proposition of the appellant's term that if the court is going to have regard to the budget speech, then they should be afforded an opportunity to put up an affidavit and tell the court how they see it from their perspective?
Yes.
because it's a factual issue, these factual issues in the budget speech, and they haven't been given an opportunity.
We would submit that they could have pleaded over and responded, but yes, if necessary, that affidavit could be filed. We would seek the opportunity to file a brief reply, although it would be unlikely to add anything. But yes, that may be a practical solution. Yes, Justice Betzer. I must deal with some of the law, because much of the debate turns on the legal principles. We've set it out in the core principle.
Doing so, might I remind you that you shouldn't repeat
I'm indebted to you.
Say to either whatever was canvassed
Yes.
by
I intend to deal primarily with one new authority which has not been addressed by the appellants and which is decisive on most of the main legal questions regarding progressive realization, reasonableness, and retrogression. We've made our submissions that the case rests on Section 27 of the Constitution alongside 33 and 9.1, the Covenant on Economic, Social and Cultural Rights, importantly now binding on South Africa, having been ratified in 2015, the African Charter, also binding on South Africa, Paja and the principle of legality. In their heads of argument, National Treasury sought to distinguish, the argument began by trying to distinguish Blue Moonlight. Blue Moonlight says that the state cannot rely on budget constraints if it has failed to budget for its constitutional obligations, paraphrasing. They say Blue Moonlight doesn't apply because it was concerned with immediately executable, immediately enforceable, realizable obligations. That has already been confirmed to be incorrect in Commando, which Treasury did deal with. Commando was concerned with the same emergency housing program and held that it is subject to progressive realization and that retrogression applies. But this is the more crucial authority. It's the decision of the Constitutional Court handed down 2 months ago in Adonisi versus City of Cape Town. We referred to it in our supplementary heads of argument and quoted from it on a different issue. Adonisi does a number of things. It packages very helpfully the approach to reasonableness review for socioeconomic rights established from Grootboom through to Mazibuko, in particular in from paragraphs 67 to 70. There it makes one particularly important decision. Justice Mhlantla, in a unanimous decision, says that Section 26 and 27 are textually the same, and the same approach to reasonableness applies. We are here dealing with Section 27 today. So the same approach adopted in Adonisi and all of the cases building up to it applies to the right to social assistance. In terms of the test for reasonableness, the court effectively restates the Grootboom plus Mazibuko test. No unreasonable exclusions. This case is largely about unreasonable exclusions. That the right must be progressively realized with flexibility, and importantly, that the state must review its policies on an ongoing basis to progressively realize the right. What happened in Mazibuko? Amend, improve along the way, close gaps, realize the right.
There can't be any other way.
There can't be. We are a work in progress, Justice Pete.
Yes. What I'm saying to you is that if you have to ultimately comply with the dictates of Section 27, one, you have on an ongoing basis, as you say, the review of policies until you get to the ideal situation.
Indeed, Justice Pete, and it's that the order seeks. And it may be more elegantly framed, but it's that the order on the grant and the threshold seek to enable the state to do. And Adonisi went further. It dealt with resource constraints, and it dealt very robustly with the budget defenses raised by the City of Cape Town. The City of Cape Town, the essence of the City of Cape Town's defense was it is unaffordable to build social housing in central Cape Town. And the court unanimously rejected that, even though the evidence was that it was more expensive to do so than on the periphery, because of the obligation to address spatial apartheid. But this is the relevant part. The court engages robustly with the budget and even ultimately orders the state, in the structural interdict, to report on the budget allocation for social housing in Cape Town. We don't go that far. No part of the order requires reporting on the budget. In Adonisi, the court has done so, and indeed there are some other judgments where it has happened. The other crucial aspect of Adonisi, and my learned friend dealt with Commando earlier. My learned friend made the submission that Justice Bilchitz's separate judgment in Commando on non-retrogression was a separate judgment, a two-judge judgment. The unanimous court in Adonisi fully adopts that approach to retrogression and all of the authorities on which it is based. So that is now our legal position. It approves the commando test, where the focus of retrogression is on the impact on individuals, not the intention of a government policy. Did the government policy conduct have a detrimental impact on individuals? If it did, obviously a material impact. If it did, then it's retrogression. That doesn't mean it can never be justified. What it does is it puts the onus on the state to explain and justify, and that's a high threshold. It doesn't mean that the state can never take backward steps, but when it does, it must justify them fully. And those we submit are the core legal principles that apply in this case, and Adonisi is determinative. And the court gave a detailed structural interdict, somewhat more complex than our own, which included reporting on the budget allocation. One other case that has done so actually concerned this grant. It's the judgment in the Scalabrini decision, early on, the High Court decision, which brought permit holders and asylum seekers into the scope of the SRD grant. That order of the High Court also required reporting on the budget that had been made available to do so. We don't seek such an order. We leave that to the process. It now leaves me to deal with the discrete issues. I've really been dealing with the big picture. In the course of doing so, I've dealt with many of the specific regulations that are under challenge, but there are some additional points not made in our heads that I'll seek to convey. There are three sets of issues in terms of the relief. There are the barriers, the 5 regulations that prevent people from accessing the grant. There are the 2 values, the grant and the threshold, and systemic non-payment. Those 3 sets of issues. Dealing first with the barriers, we have an overarching submission on these barriers, which is that budget and affordability can never justify arbitrary exclusions. And here I must respond. My learned friend for the Treasury made the submission that IEJ and Pay the Grants have accused the state of acting in bad faith in seeking to suppress the numbers. We have not used that framing. What we have said is that the state has acted for an improper purpose, and that appears abundantly from the papers, that the conditions were designed to suppress the beneficiary numbers, to keep them down, in the language of the papers, to stay within a budget envelope. And we submit that if that's the aim, it must be done front on, by way of adjusting the criteria, for example. It cannot be done, for example, by making the grant online only, so that some people can't get into the door and apply. It cannot be done by using unreliable databases to winnow out a third of applicants. So that's the overarching submission, that the barriers questions are not about budget or affordability, or not in the same direct way, perhaps, as the values questions are. But then dealing with the specific issues, the online only to begin with. And this was largely, I think, resolved in the exchange between the court and my learned friend, Mr. Van Heerden. The submission was made.
Mr. who?
Mr. Van Heerden.
Oh, I thought you said Van Heerden.
We also submit, since it's mentioned, that Van Heerden is not applicable and doesn't assist, because that was concerned with MPs' pensions, and a 370 Rand hunger and poverty grant is quite a different matter. The consequences of excluding someone are quite a different matter. If I get time, I'll deal with it. Mr. Van Heerden made the submission that the self-help kiosks have been rolled out nationwide, and that, and Justice Petse put it to my learned friend, that surely if an applicant walks into an office, they will be assisted to apply. And their case has evolved since the High Court. In the High Court, we argued that since self-help kiosks have been piloted in a certain number of offices, there is no impediment to rolling them out across the country. And we relied on the treatment action campaign, which the court will recall. In that case, Nevirapine had been piloted, and the court held it should be rolled out. That was our argument. Now they appear to argue that it's been rolled out countrywide. That is not the factual position on the papers. The factual position on the papers is that it has been piloted in some kiosks. We're not told which ones, how it's done. The legal position, because this is a challenge to the regulation, is that applications may only be made online. So unlike any other grant, you cannot walk into an office and expect to be assisted or request to be assisted. There's one, and this is again an overarching submission that applies to all of the barrier provisions, and it may be of some reassurance to the court in terms of the impact of implementing these orders of invalidity. And it applies to the online only, but also to all of the others. These orders will only apply to new applicants. So all of the existing approved beneficiaries continue to be paid the grant unless for some reason they become ineligible. For example, their income goes above the threshold. Then they lose the grant. But if not, they continue to receive the grant. So what we're dealing with the online only, but also any other, is that new beneficiaries, whether it's 5% or 10%, those people without access to smartphones, with disabilities, without digital literacy, which the facts overwhelmingly confirm are present, will be able to walk into an office and be assisted. There was a fundamental misunderstanding, and this is the other crucial point on the online only. DSD's evidence in the answering affidavit fundamentally misunderstood the applicant's case on this issue. They understood that we wanted to replace online with manual entirely. So everything that they say in the answering affidavit about how that will be unaffordable was premised on an understanding that all 15 million will have to apply manually. That has never been the case. It's not the relief. It's not the basis of the order. The order gives an additional option for that minority of people who can't apply online to do so in person. And it's an entirely appropriate order and crucially necessary. On the interpretation of the two terms, we've made our submissions. They have to mean something. In the High Court, both sets of appellants initially declined to offer any interpretation. What we know is that the working interpretation applied by SASSA is any money. So insufficient means, which is defined to include income and financial support, is understood by SASSA and applied day to day to mean any money that you may hold for any reason whatsoever, acquired in any way whatsoever, with one exclusion only, which is child support grants. So they've accepted that must be excluded. Treasury's case evolved during the High Court. They now accept that you must at least exclude money held on behalf of others. But we submit that the interpretations of income and financial support for which we've contended accord with the ordinary meaning, and they give effect, crucially, to Section 27 of the Constitution. They need to be interpreted with a view to the purpose of the grant being to enable people to support themselves. Money that you hold because you are the family member charged with organizing a funeral for your family does not enable you to support yourself. Money that you hold because your sibling doesn't have a bank account, or because your spouse has transferred money to you to pay for the monthly groceries, and that money is then double counted in both spouses' accounts, doesn't enable a person to support themselves. So we submit that the interpretation of income as effectively being money from work or investments, and we define work to include informal labor also, so informal employment, is an entirely
Mr.
defensible.
Isn't this all in your head?
It is.
I'm trying to help you.
More important issues, indeed.
In terms of your time, not with your substantive argument. I saw Mr. Marcus
just
giving
wanted
me
to-
the evil
just wanted to say.
eye. Evil eye.
We submit that the regularity and obligation elements are necessarily part of those definitions. Without them, you're left with payments that don't enable you to support yourself, because it's only payments to which you have a right and which you can reasonably expect to receive, because they're regular, that you can support yourself. So an ad hoc payment doesn't enable you to do that. There's one further point, and it's a perversity with respect in the appellant's argument, which is that if you are starving and a family member sends you money to stop you from starving that month, on their interpretation, that will disqualify you from getting the grant. And that can never be the purpose or a sensible interpretation of those terms. It's perverse for this reason. It creates a perverse incentive. It tells people, if you want to secure this grant, you must starve. You must not seek ad hoc assistance from a family member to keep you from hunger. And that's why those regularity and obligation elements are necessary in the interpretations. The databases and bank verification we've dealt with quite substantially. I just want to highlight one feature because it didn't arise. Again, it's about facts and the evidence. And I think the question was raised by justices, what are the levels of exclusion? It does appear from the papers, and we've provided references in the facts. Some of the sources indicate that the database exclusion errors may be as high as 33%. So 33% of applicants are wrongly excluded, incorrectly excluded. We submit that while there may be some room within reasonableness for a level of exclusion errors, it cannot reach that level. Or as Justice Hughes pointed out, the admitted a lot of exclusion errors also passes the threshold. The other submission that I must make in this respect is that the original notice of motion provided two alternatives in terms of the relief, and the High Court opted for the primary relief. The primary relief effectively kills off database verification and bank verification at the moment. It strikes them out. It leaves SASA, to deploy all of the mechanisms it uses to decide every other grant application. So all of the declarations and affidavits, that's what is used for every other social grant. So we submit that that is workable. But if the court were concerned that this goes too far, the alternative relief that we sought in the notice of motion was essentially a structural interdict requiring DSD and SASA to go and fix the problems in the databases and bank verification and report to court on what is done to bring those exclusion errors within a reasonable level so that those systems can be deployed. And I know that the amicus curiae will address some of these aspects in more detail, but I point to that alternative relief that we sought. The High Court opted for the primary relief. Our submissions on bank verification have been made in the heads. I won't repeat them. The budget cap. Justice Petse raised a question that, this has never been reached. It's never been triggered. It's only threatened. And I think there was an interaction suggesting that, perhaps from Justice Keatley, that, only once it happens can it be challenged or should it be challenged. We submit that once a right is threatened, that crosses the threshold and provides standing and the proper basis to intervene and strike down the regulation. I also pointed to FA 37 earlier, where DSD itself warned that after month 9 we might have to cut off because we're reaching the limit. But even without that evidence, we've got one authority on this point, which is Black Sash, the decision of the Constitutional Court, 2017, Volume 3, South African Law Reports, 335, decision of the Constitutional Court at paragraph 43, where the Constitutional Court held in the context of social grants that a threatened breach of Section 27 triggers the Section 172 remedial powers requiring the court to strike down the regulation. We submit that budget cap needs to be struck down. My learned friend for National Treasury made the submission that there's an implied restriction to that effect in relation to the other social grants. There is no budget cap in relation to any of the other social grants. There are ordinary expenditure controls that Treasury implements, but none of those say that SASA, when it reaches number 301, Justice Petse, doesn't pay number 301. What they say is that SASA and the department must report to Treasury, seek additional budget, etc. They don't turn off the tap in that arbitrary way. We submit that regulation also must fall. And that declaration was appropriately made. In relation to internal appeal, pointed to the facts earlier. Let me provide one reference. I said I would in terms of the number of appeals. Over 1 million a month, 12 million in a year. That appears at Annexure FA 74 to the founding affidavit, Volume 3, page 536. So we're dealing with an enormous number of appeals. We also have from DSD's reporting that over 99% of appeals are dismissed. And that may be in part due to the no new evidence on appeal, but it ought to be a massive red flag. If 1 million people are appealing, and less than 1% of the desperate people, knowing that there are those eligible beneficiaries, and 99% of those appeals are refused, that ought to be a massive red flag.
Could that not be attributable to the fact that the appellants are not allowed?
Perhaps in part, Justice Petzer. But I must deal here, there was an idea that arose in the debate earlier that internal appeal and opening it up to wide appeal solves all the problems. We submit that that's not so at the level of law and fact. At the level of law, it can never be justifiable to subject vulnerable social grant applicants to unlawful procedures on the basis that they may be able to cure them on appeal. That's the principled argument. But at the level of fact, it simply won't fix the system. We're dealing with a broken system. All of these aspects interrelate. The broken the databases that need to be improved, the bank verification, the online-only applications, and a widened appeal, though essential, is not sufficient to solve those problems. It will go a long way, but it won't solve the problem.
But Mr. Brickel, your challenge to the appeal process was specifically on the narrow issue.
On not allowing new evidence. Yes, Justice
It was on not allowing new evidence.
Yes, that's the full extent of the challenge. I was responding to it, I was making a different point. Fixing that doesn't solve the other problems, the other 4 problems, the other regulations that were also struck.
I don't think in that interchange about broadening the appeal, I think we were specifically dealing with the challenge rather than...
I may have misunderstood Justice Mayer in the exchange, but to the extent there has been some, in a sense, that is Treasury's argument. Treasury has always conceded Regulation 6, the wide appeal, and seeks to argue that, well, you can solve you tidy it up afterwards. Allow all of these people to appeal, and you can fix it afterwards. We submit that that's it. The appeal needs to be fixed. People need to be able to put up that single document to say that I held this money for a funeral or I'm not on UIF, but it's not an answer to all of the other problems. It remains for me to deal with the crucial issues of the values, the grant itself, and the relief. And I'm conscious of time, Justice Hughes.
Yes, that's
I would ask for 5 more minutes to take us to past, and I can conclude in that time with leave of the
5
court.
more minutes?
Yeah.
5 only.
In relation to the 2 values, the 370 Rand value of the grant and the 624 Rand means threshold, we submit that there has been a retrogression in failing to increase them over these 7 years, with the exception of the single increase to each, and that constitutes a significant failure of progressive realization that has not been justified by available resources. The order that we seek is not prescriptive as to either. So it does not fall foul of the Mazibuko problem. In Mazibuko, what the Constitutional Court said is, it is not the role of the court to say how many litres. But the court did not say that there isn't an obligation to progressively realize the right. It was saying that that is primarily a function. The content of the right is primarily to be determined by the legislature and the executive. The order enables them to do so. It puts them to terms to do so. It identifies the relevant considerations, none of which can reasonably be argued not to be the crucial considerations. We have always accepted that affordability is a relevant consideration. It doesn't appear expressly in the list of factors in the order, and we would accept that it could appropriately be added. But we've always accepted that it informs the inquiry. The case advanced as National Treasury, and we submit in an overstepping of the line, contrary to DSD's policy position, is that no increase whatsoever to either can or should be entertained. That there is no obligation to plan to progressively realize either the grant value or the threshold in the way that the table that was presented to the President does. and that the court would be overstepping to intervene. We submit that, to the contrary, the facts overwhelmingly demonstrate that the narrowly tailored intervention that the High Court crafted is appropriate in the circumstances. And Justice Keatley, to allay your fears, this court is not faced with that future case when those values are set on whether they're reasonable. This court does not need to speak to what those values
I
would
wasn't concerned about this court. I was
No
just
court.
concerned about
be. No
The
court,
courts.
Justice Keatley. We've seen DSD's proposals to increase the grant value to 663, alternatively 500. The order doesn't prescribe those. What it does is it opens up the space, the constitutionally appropriate space, for DSD and Treasury to engage, and for the Minister of Social Development to report to the court on a plan in consultation with the Minister of Finance to progressively realize those values, to remedy the retrogression in time and subject to affordability. In terms of the means threshold, it was originally set precisely to be at the food poverty line. That was the reason that this random figure of 624 Rand was selected, and it's just been frozen there since 2022. A rising tide floats all boats, but what the state has allowed to happen is that the tide of inflation and the cost of living have risen, and the beneficiaries have been allowed to sink beneath the surface of those rising costs. What the order will enable is for a constitutionally appropriate reconsideration of that threshold and a plan to raise it in time. We made the submission on the facts in terms of the grant value, that the grant, and both in fact, the grant has been underspent every single year. In the face of that, materially underspent, and the budget reduced from an original 44 billion down ultimately to 33 billion, year on year. Those facts cannot stand alongside a claim that no increase whatsoever is affordable, where there's been consistent underspending. The second material fact is the 20 Rand increase, which Treasury explains was achieved simply by a reweighting of priorities, and which constituted less than 1% of the social assistance budget. Those are the sorts of scale of increases we're concerned with in future. I'll close with some final submissions in my remaining minute on relief. We submit that the order is unexceptional. It is a stock standard social rights order that has been granted by this court and the courts below and the Constitutional Court in a range of cases. We've referred to Adonisi, but there are other courts that have gone much further than the limited order requiring a plan taking into account relevant considerations. Mwelase appointed a special master, taking that power away from the executive, putting it in the hands of an independent actor. This court's decision in Nuza created a class action to benefit unpaid social grant beneficiaries in numbers. The order in this matter simply strikes down the unconstitutional regulations with appropriate reading in to deal with the online only and the appeal issue, and in relation to the structural orders provides a plan. 4 months, we submit, is eminently reasonable. These regulations are amended each year. Every year, DSD and National Treasury do the very exercise of considering what the grant value and the threshold should be. Every year since 2024, for the grant value, they've determined that it should remain the same. The 20 Rand increase was determined and announced in a period less than 4 months. So we submit that a 4-month period is eminently reasonable. A 2-year period is entirely inappropriate for a range of reasons, including the reason that Justice Petse pointed to, the life of the regulations, but also because these are rights bearers and that there needs to be effective relief within a reasonably immediate time period. We submit that 4 months is eminently reasonable.
How would that fit with fiscal timetables? Do you know?
At this stage, Justice Keatley, it's only a plan. So the plan would need to align with fiscal timetables. It would, for example, need to say that these will be the steps in terms of next year's budget. It doesn't entail any immediate increases. So it's a plan that can entirely accord with fiscal time periods. The timetable that the Minister and the Minister of Social Development and the Minister of Finance can tailor to accord with that timetable, and ought appropriately to do so. They may indeed say that this is the plan up to this point and that there will be further steps taken. But it's only a plan. Ultimately, we submit that a structural interdict of that sort is exceptionally necessary in this matter because of the separation of powers and rights considerations that we've addressed. The Department of Social Development in Pretoria is seeking to discharge its constitutional obligations. The order provides a framework to enable it to do so, subject to affordability and affordability concerns. Justice Hughes.
Costs.
Justice Hughes, if I might just. Justice Hughes, I didn't address the systemic non-payment at all. We have one submission on that. On the papers, it's not a historic issue. On the evidence put up in the founding affidavit, there were over 1 million unpaid approved beneficiaries at a time in each reporting month. And even in the midnight special document, SA4, that was put up without an affidavit, 5% of approved beneficiaries remained unpaid for 2 years. It's not a historic concern. In fact, on the papers, it remains a pressing concern at a matter of at scale. In terms of costs, Justice Hughes, we do submit that the matter warrants the costs of 3 counsel. In the Rule 11 application, we sought punitive costs, but it becomes complicated with respect to deal with the different parts of that application. If successful there, we seek costs on the same basis as in the main application. We have sought costs of 3 counsel, which we submit are appropriate in the circumstances. My second junior has been indisposed today, as I drew to the court's attention. And Justice Hughes, of course, BioWatch applies the other way if we're unsuccessful.
Cost of 3 counsel in relation to the application.
Justice Petse, we would accept just costs of 3 counsel where employed, and we would accept that the Rule 11 application could appropriate. In a matter of this sort, we'll deal with it together, but we would accept 2 counsel on that application if it's in the discretion of the court. As the court pleases.
No questions? Thanks. Thank you. At long last, the amicus has an opportunity to be heard.
Justices, it seems I'm doing the kind of graveyard shift, so I hope that I can keep you entertained.
Okay, so you still want your 50, what would you
20
say?
minutes.
Your 20 minutes.
Hopefully I would have dealt with everything and then that's it. No questions from the bench and then we'll get right into reply.
Hopefully.
May it please the court. Before I put the amicus submissions to the court, may I explain why they bear on the way this court decides the appeal. The appeal is not only about whether particular applicants qualify for the COVID-19 SRD grant. It raises a question this court has not had to decide before. How the Constitution treats an administrative decision that is in reality made by a machine working at scale, the verification of millions of applications a month, on which survival support depends. That question does not stop with the parties. How the court answers it will shape the way automated decision-making is judged across the delivery of socioeconomic rights. The amicus was admitted to assist the court on precisely this question. If it goes unexamined, the court will decide this appeal without reaching the very question that gives it importance beyond the parties. May I frame at the outset what the amicus means by an automated decision. It is a decision that a computational system reaches in the place of human judgment. Here, when an applicant qualifies for survival support, and it differs from ordinary administrative decision along 3 axes that matter in law. Scale, because determination are run in batches rather than one at a time. Speed, because the outcome is reached in seconds with little room for context or correction. And opacity, because the rationale sits in a data pipeline that is largely ineligible to officials who signed it off and to the applicant who refuses it. It is these features that turn small design choices into systemic effects, and that lead the amicus to submit that a decision of this kind calls for more searching review, not less. With the court leave, the amicus makes a single submission, which I will put to this court in 5 short propositions in a moment. It concerns the constitutional treatment of an administrative decision that is an automated and operates at scale. May I assure the court at this very outset that in making this submission, the amicus has not gone outside the record. It leads no new evidence. It asks the court to accept no facts that are not already before it. It takes the facts as the record and the court to co-found them, and confides itself to the law around those facts. Only one objection to that submission has been made. In its supplementary heads of argument, the third appellate consents that the amicus premise is not on the record, that there is, in its words, no evidence that verification is automated. I will answer that objection directly and show this court from the record why it cannot stand. Justices, from the onset, when the counsel for the first and second respondent stood up, they said it was fully automated. So I will just deal with that, but I'll deal with the submissions of the third appellant's submissions about not being in the record. Justices, the amicus case can be put, as I've said, in 5 propositions. I will take each of them in turn. The first is a matter of constitutional principle. When an administrative decision that determines a person's access to survival support is, for all practical purposes, made by an automated system operating at scale, it does not fall outside the reach of Section 33 of the Constitution and the Promotion of Administrative Justice Act. If anything, the context calls for a more searching review, not a differential one. The second concerns human oversight. A nominal human sign-off on an outcome that is, in substance, machine-determined does not cure the process. The question is not whether an official formally approves the result, but whether an individual mind has actually assessed the applicant's circumstances. The third is about reasons. An automated decision that withdraws survival support requires individualized, intelligible reasons. A bare rejection, delivered online, does not meet the constitutional flaw for administrative decision-making. That flaw is not novel, justices. Section 33(2) of the Constitution and Section 5 of PAJA already guarantee adequate written reasons whenever a person's decisions are adversely affected. And where adequate reasons are not given, PAJA presumes the decision was taken without good cause. And this court has already fixed that standard. In Minister of Environmental Affairs and Tourism versus Pambili Fisheries, 2003, Volume 6, Essay 401, SCA. In that decision at paragraph 40, the SCA said that reasons must explain a decision so that an affected person can say, even though I may not agree with it, I now understand why the decision went against me. A bare system-generated rejection cannot meet that standard. The fourth is the opportunity to correct an error. When adverse decision rests on a database or bank verification input that may be wrong, fairness requires that the applicant be able to correct that error, not to begin a fresh, time-sensitive application from zero. That is what Regulation 6C denies. It provides, when lodging an appeal, and I quote, the appellant or the person acting on his or her behalf may not submit any evidence or information which was not provided to the agency at the time of the application. So an applicant wrongly excluded on a faulty input cannot correct it on appeal. And because Regulation Cap 6A now makes a verifiable bank account compulsory for every applicant, The discretion that Regulation 2.3 appears to confer is in operation no discretion at all. And the fifth draws on comparative authority. These propositions are not novel. They are worked out in 4 decisions that no party has placed before the court: the Dutch decision, the Australian decision, and 2 decisions from the European Union, which we've referred to in our heads of argument. The amicus relies on them at a level of principle. Nothing in its case turns on the particular technology that SASA uses. Justices, if one stands back from the particular facts of those 4 cases, a single principle runs through all of them. Where a person's access to something they depend on, whether it's credit, a benefit, or sustenance itself, is in truth determined by an automated processing of their data, the decision does not escape legal scrutiny because a machine produced it. The opposite is true. The automated outcome that effectively determines the result is treated as the decision itself and cannot be insulated from review by a nominal human sign-off. The decision must rest on a genuine, individualized assessment rather than a blunt computation, and the person affected is entitled to a transparent, intelligible explanation of how it was reached. That principle is what the amicus asks this court to recognize. The same principle that Section 33 of the Constitution and PAJA already expresses in our own law. The objection by the third appellant is confined to a single narrow point of fact. It says that the amicus premise that the SRD eligibility is determined by automated verification with human oversight calls a nominal. It says in its heads of argument, it is not on the record. There is simply no evidence in the appeal record to support the notion that verification is automated. This you'd find at the third appellant's supplementary affidavit, paragraphs 3 and 6 to 7.
Paragraphs 3 and 6 to 7.
Yes. Justices, with respect, the objection does not survive contact with the record. Justices, at record page 1698, which is volume 10,
Yes.
it's paragraph 130 of the judgment of the Court of Quo. Twala J made an express finding of fact, not a recital of the party's contention, but his own finding. This is what paragraph 10 says at record page 1698, volume 10, paragraph 130. The use of the verification process, which is fully automated, is unfair and unreasonable and offends the provisions of section 9 and 27 of the Constitution. That finding is grounded in the second appellant's own evidence. SASA's executive manager, Mr. Van Vrede, deposed at record page 1180 that the verification process is reasonable and relates to a government purpose. And at record page 1181, which would be paragraph 34 of its answering affidavit, SASA's own evidence says that it verifies millions, now more than 15 millions of SRD applicants every month. And at record page 1183, paragraph 40, SASA's own evidence is that manual processing of that caseload, and I quote, will be impossible for SASA to process all the millions of applications received monthly. Justices, the second point that the third appellant's supplementary affidavit says is that the exclusionary effect of the process is heavily contested on the record. The words of the Court of Quo say the opposite. The unreliability of the government databases was accepted by the parties. This is what Twala J says at paragraph 124 of the Court of Quo judgment. The evidence of erroneous exclusion was uncontroverted, is what Twala J says at paragraph 125 of the judgment. And the respondents were, as the Court of Quo puts it itself, dead silent on the confirmatory affidavits dealing with that exclusion at paragraph 52 of the Court of Quo judgment. Those are not words a court uses to describe a life dispute. The Court of Quo went even further. It found that bank verification process was a blunt instrument and inhumane. This is at paragraph 129 of its judgment. A description it recorded SASA using itself in its own reports This you'd find at paragraph 132 of the Court of Law judgment. Justices, if the court accepts the propositions that I've outlined, what would a system that honors the people that we've spoken about look like? The amicus does not ask this court to design that system. That is for the executive, and it leaves no evidence on how SASSA should run it. But the Constitution sets a floor beneath whatever is chosen. The amicus commends to this court 7 features of that floor, each already recognized in our own law or in the comparative authorities that I've mentioned. And this is also highlighted in the expert affidavit that the amicus has provided to the court, justices. The first is, access must not turn on a single digital channel. A system reachable only online excludes the very people it serves. Those who, on the finding of the court at paragraph 95, have neither smartphones nor internet access. Hybrid access, both online or in person, is not a convenience. It is a condition of equal access to that right. The second, every automated rejection must be subject to genuine human review before it becomes final determination. That is the human in the loop requirement that Article 14 of the European Union AI Act now makes express provision, and that the Netherlands adopted after its childcare benefit scandal. To reform, born, as ours would be, of the harm that follows when a machine output is treated as the decision itself. The third, the model that drives these decisions must be tested rather than trusted. 2 steps do that work: an independent, algorithmic, and data fairness audit of the bank verification model, and a human rights-based impact assessment alongside it. Neither is a novelty. The EU AI Act secures both through its conformity assessments, and Canada requires it under its directive on automated decision-making. Together, they let the reliability the quote-unquote doubted be examined rather than assumed. Fourth, and here our constitutional render demands it, every eligibility decision must come with clear, sufficient reasons, and the applicant must have accessible means to contest how they believe rests on algorithmic error or bias. That is Section 33 of the Constitution. It is the third and fourth propositions of this argument gives practical form. The fifth one, the communities most affected must have a genuine, structured voice in every redesign. Not a comment period after the fact, but a real input into the decisions that govern their access to survival support. Sixth, oversight requires capacity. Human review is illusory unless the official who exercise it understand the system they're overseeing. Investment in SASSA staff is therefore not incidental, but essential. The correction of bias requires more than technical fixes. Seventh, whether the exclusion worked by means testing might be in time be reduced by a phased move towards a universal basic income. That approach has now been piloted in countries like Kenya, Namibia, and India. Nothing in the amicus case turns upon it. Justices, a single thread runs through all of this. The answer to an automated system that fails the poor is not a better algorithm, but a system designed from the ground up around the realities of those it serves. Around informal and irregular income as the norm, it must accommodate rather than an exception it must punish. And built to price transparency and human oversight above efficiency and opacity. That is the assistance the amicus hopes to leave. Not that the court designs the machine, but that it insists the machine remains answerable always to the people who live, whose lives it decides. Justices, may I end with this? The single objection raised to the amicus case, that the record does not show the process to be automated, is with respect answered by the record itself, by the finding of the court of quo, by SASSA's own evidence, and by the respondent's own pleaded case. I need not take the court through it again. What the amicus has sought to do is narrower, and I hope more lasting. Behind the words automated are millions of people, amongst the poorest in the country, whose access to food and to means of survival turn on how these systems these decisions are made. The amicus has placed before the court 4 decisions comparatively in different jurisdictions in which courts have confronted the same question, and it has offered a principle to ensure that even at the scale of millions, each person's rights to dignity, to equality, to just administrative action are not lost to the machine. That is the assistance amicus once was admitted to give, and it offers it in support of the court, not any party. The amicus asks only that the Constitution's promise of just administrative action reach those who depend on this grant as fully as it reaches everyone else. And it respectfully submits that the order of the Court of Law should be affirmed. Unless there is anything further which I can assist the court with, these are the amicus submissions.
Thank you. Any questions?
As the court pleases.
Any questions? Thank you, Ms. Magurewani. Mr. Marcus? I think we just got enough time for you to reply.
I'm not going to be doing it. My learned friend, Mr. Friedman, will be doing it, but I can tell you that I understand my learned friend, Mr. van Eerden, does not propose to reply. So I'll leave it to my learned friend, Mr. Friedman, that the anticipation is about 20 minutes.
Yeah, no problem. Thank you, Mr. van Eerden. It's 20 minutes. It's going to be 20 minutes. Okay, we're going to... Mr. Friedman, we're just going to take a short comfort break.
I would appreciate it.
5 minutes.
As the court pleases.
Thank you. Are you okay?
I only want to speak about 3 topics. I want to address this notion that there's been some sort of a separation of powers breach because of Treasury's conduct in relation to social development. Then I want to address the question of what the available resources, the role that available resources play in this matter, arising from what my learned friend has submitted. And then I lastly want to address briefly the question of reasonableness, whether the plan that the appellants have adopted is reasonable. And in the course of addressing those 3 topics, I'll hopefully sweep up the main points that we wanted to address in reply. If I may just say before I get into those 3 topics, just on the Rule 11 application, I'm not going to address the court. I understood my learned friend to accept that if the budget speech were to be admitted, the appellants would require an opportunity to answer, which is with respect to a point well conceded. Our point simply on that is that it's not just a simple matter of keeping the court updated with the most recent facts. The implications of that budget speech are it's a factual matter. Part of their case is to say that the Treasury has only justified the plan with a back of the envelope calculation, but then they don't. But then the notion is that the budget speech and its implications can just be slipped in. So we would need to respond to that. But we take the primary position that it's not necessary and that it just simply shouldn't be admitted.
Well, I wanted to add that to your list that you must address us on this budget speech issue on whether you're going to file, and if you file, time frames in respect of the filing.
Well, the issue is that this is partially not our problem, to put it colloquially, but the point is that they brought an application where this is my framing, they try to smuggle that speech in as just keeping the court updated. It's not immediately clear from that affidavit precisely how far they go with the budget speech. The reason that's relevant to timing is to be able to explain the fiscal position in detail, we would need a bit of time.
Yes, hence I'm saying that we inclined to give time to the appellants to respond.
Well,
but you can address me at the end when you confer with your leader.
Unfortunately, I was actually looking around for the client and the instructing attorney, who I think have gone to catch a flight. The issue is that I just know from experience with Treasury that if I say a month, they'll tell me it was too short. But I know the court's I know that you've been told that there's an urgency, and I know that the court wants to be efficient. But to do it properly, we would require, I think, at least 6 weeks. And I know, but with respect, Justice Keatley, this is why we say this shouldn't be done this way. Because it's a rolling factual record on their version. It's a rolling factual record. Whenever a new budget speech is given, then the only implication of their approach is there must be a full further exchange of affidavits. Because we can't.
Yes.
Would you perhaps leave that to your leader to call up?
As the court pleases. And then if I may just say on the question of the amicus, I'm not going to address the court in reply. The points made by my learned friend are also points we addressed in our submission in response. So I just ask the court to have a look at our written submission on that, and we stand by that.
We definitely will do it.
As the court pleases. Okay, then if I may just start with this point about the so-called separation of powers difficulty. With respect, that submission is very difficult to understand. It's, first of all, wasn't pleaded that way in the founding affidavit, if I may say so. But let's assume for the present purposes that that's not an issue. The argument was advanced that the ultimate responsibility lies with social development. You were taken by my learned friend to extensive references in the record to show that the Department of Social Development wanted to increase the value of the grant, was almost frustrated, or in fact was frustrated with Treasury for not being amenable to that increase, critical of Treasury, etc. He made all of those points to then buttress the main submission, which is that social development wants to increase the value of the grant. That is its policy decision, and all they want, and these were his words, he said this expressly, all they want as the respondents is to give effect to social development's policy. But the legislation itself makes clear that the quantum and the details to do with implementation, etc., have to be dealt with in regulations, and they have to be made with the concurrence of the Minister of Finance. That's common cause. Just quickly, the relevant provisions are sections 13 and 32 sub 2 of the Social Assistance Act. So Parliament has decided that not only the quantum but also the implementation of the payment of this form of social assistance must be done in regulations which have the concurrence of the Minister of Finance. That's what Parliament has decided. And there is no way around confronting the implication of what concurrence means. So there's simply no way to get around the pragmatic and factual reality that the Minister of Finance, if he does not agree with the quantum, has a veto. And it must be like that. That's why Parliament did this deliberately, because it would be nonsensical with respect for social development acting on its own to have the power to decide the value of the grant without the permission of the Treasury or without the buy-in of the Treasury. With respect, it's a very blinkered view of this particular form of social assistance which does not take account the rest of the state's responsibilities. My learned friend almost tried to make that into a virtue by saying, well, you could say the same of any department program. He said, the fact that this is going to cost money and have budgetary implications, you could say the same of any department program. And he tried to imply that, therefore, it's not an excuse, but it's the opposite. The truth of the matter is the question of what to allocate and in what circumstances and in what priority is a classical policy decision. It's an executive-minded policy decision which has to take fiscal considerations into account. Not only does the legislation say that by making the concurrence of the Minister of Finance compulsory, but as a matter of constitutional logic, it has to be so. Because otherwise, the Department of Social Development could simply set the value at an unaffordable rate. To just say it shows the logic of what I'm submitting and the illogic of this approach based on the so-called breach of the separation of powers. And just the last point I make on that before I move off this point is that it's dealt with in the papers, this very issue. If I can just give two references, it's paragraphs 30 and 34 of National Treasury's answering affidavit. And that's in volume 4 and at page 742 to 743. Those paragraphs with respect show that all of these points that my learned friend made about the attitude of social development, the desires of social development, the policy choice and goals of social development, with respect, those points are against the respondents. They're not with the respondents. Because if you look at those two paragraphs of the answering affidavit, the court will see that the minister confronts this, the Minister of Finance, my client, confronts this head on, and he says there are differences of opinion within government about the appropriate policy choice to adopt to social assistance. He expressly says in those two paragraphs, social development supports an universal basic income grant. And then he goes on to say that that approach is unusual, is the word used, in the international arena. And he says it's a difference of opinion on policy. So with respect, the point is against them because it shows that there is a strident policy debate within government about what the appropriate way to fund social assistance is and what levels of social assistance one needs in the first place. And so that being the case, it goes straight back into the heartland, which the Constitutional Court and this court have repeatedly said is not for the state, for the courts to get into, to decide which line items should be reallocated, which priorities should be at the top of the queue. And in that respect, it's also wrong for them to submit with respect that there's no plan, and that Treasury's attitude is that there should be no plan. My learned friend said that on multiple occasions, that the Treasury's position in this court is that, number one, it's unaffordable, and number two, that not even a plan is necessary to make it affordable. That, with respect, is not true. Treasury repeatedly says in the answering affidavit that it's paying as much as it can afford, but that there is also, in parallel, a series of government interventions which are designed to alleviate the poverty of working age individuals. So it's two-pronged. We're paying as much as we can for now on this grant, but there are also other policy interventions to address the poverty of working age individuals. And just then now on the question of resources, I just wanted to quickly draw attention to the fact that if one, this court has seen our heads of argument, and I know that I'm under time pressure, but I just ask the court in its own time to just trace the evolution of the socio-economics rights cases, starting from Subramoni in 1997 and going all the way to Adonisi, which my learned friend addressed the court on. I will speak about Adonisi in a bit more detail in a moment because my learned friend himself dwelled on it. But if the court follows the train of all the socio-economic rights cases, what is vitally important to emphasize is there has never been a case where the government relied on a lack of resources, put up evidence to support a lack of resources, and the court nevertheless declared the government's conduct to be unreasonable. Not one. The court will look at each of those decisions and they will see that in all of the decisions that my learned friend relies on, Khoza, Blue Moonlight, Adonisi, and Commando, the court expressly says in their judgment that the state either hasn't relied on a lack of resources as a defense or has not put up evidence of a lack of resources, and therefore there cannot be any acceptance by the court of a lack of resources. If I can just give a brief reference, Khoza, paragraph 50, the court specifically says there that the state has not relied on a lack of resources as a defense. Blue Moonlight, I'll give a reference in a moment, the same thing. The court expressly said there was no evidence put up of a lack of affordability. So the point is that what my learned friends have done is that they cherry pick authorities which are all classical negative rights cases. So where somebody was evicted from a house, for example, and no alternative was made available to them, and they then draw from that conclusions about retrogression in the positive realm where it comes to budgetary constraints. And that is a leap that is not justified if one takes a slow look through each one of the judgments. If one looks at all of the judgments up into including a Commando, one will see that retrogression, to the extent that it's relevant, is made part of the general reasonableness inquiry. There is nothing special about it other than that the courts will say when a measure is truly retrogressive, it has to be the subject of additional scrutiny. But to be retrogressive, it involves, on all of the authorities that we've seen, taking away access that was already there. There is no case in our jurisprudence where a failure to keep up with inflation in a grant that is otherwise giving people more than what they had previously has been treated as retrogressive. And just the last point on that, which I just want to emphasize, can I just ask the court to look at the Mazibuko decision in paragraphs 135 to 137. Because if the court reads those three paragraphs, 135 to 137, the court will see that we are essentially on all fours here. In that decision, there was less overall water supplied to people because there was a change from an estimate basis for billing into a metered basis for billing. So to get rid of all sorts of inefficiencies with accounting, etc., the city decided we're going to give certain amount, I think it's 6 kiloliters per month free, but we're then going to charge on a new metered basis. Constitutional Court rejected the argument that because less water was received, the measure was retrogressive. Because the Constitutional Court said, how can we call a measure which is rolling out increased access over time of water in an orderly fashion, how can we call that a retrogressive measure? And it is in those three paragraphs it's expressly dealt with. And we would say with respect that this case is entirely on all fours. We had a situation in 2019 where there was no such thing as this grant. It was brought in as an emergency measure to deal with the effects of COVID, and it's now since then been on a temporary basis increased by 20 Rand. My learned friend said in his oral address how important the 20 Rand increase is. And the minister, and here we would obviously part ways, notwithstanding his submission that the minister throws his hands up and doesn't address these issues properly, the Minister of Finance in his further affidavit in the High Court, from paragraph 13 onwards, that's the one that was filed after the replying affidavit, to respond to the specific issue of the 370 Rand. he spends there in paragraphs 13 to 18 going into detail to explain that no more money was available, but the 20 rand was found as a reallocation of priorities because of the importance that it has to people. So that cannot be described by any stretch as a retrogressive measure, certainly with reference to the authorities of the Constitutional Court. And I'm mindful of time, I just now want to briefly deal with the question of reasonableness. Oh, sorry, before I do that, sorry, I said I was going to just address Adonisi. Very briefly, I just want to point out to the court. Again, Adonisi was not about the state saying they can't afford something. The question about Adonisi was about reallocation of resources when it comes to where the housing plan must be located. What's important to bear in mind about Adonisi is it's a section 25.5 of the Constitution case. So section 25.5 of the Constitution, which comes in the property clause, not the right to housing. I'm not suggesting that the right to housing was not also considered, but the right to property reads as follows. It says, the state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access, and this is an important part, to land on an equitable basis. So in the Constitutional Court, in especially paragraphs 114 to 115 and 167 of Adonisi, the Constitutional Court emphasized that the issue here was, the problem here was, the state had done nothing to address the implications of apartheid, in particular with reference to where people are located within the urban areas. So we know that the pattern in apartheid was that everybody was pushed out to the peripheries. And what the court says here in Adonisi is, here you have a situation where all you are willing to do is to put people on the periphery as part of your housing plan because, and this was also on the evidence, the value of property is too high in the inner city to justify it. That's essentially what the court found. They were saying, well, you want to push people to the periphery of the city because the property inside the inner city is too valuable to be wasted on housing plans, etc. So it's totally different. It's got nothing to do with the state saying we literally can't afford to do this. It's got to do with spatial planning and equitable provision of housing in the context of apartheid history and not wanting to reproduce for the rest of time this imbalance where people are shunted to the periphery. So it's entirely distinguishable. Then lastly, just on this question of reasonableness, the point that I've made is that retrogression is at best relevant to reasonableness. It's not a self-standing test. I've already said that this measure is not retrogressive because it gives more access. So then the question is simply about reasonableness. The first point I just want to make is just on the question of the interpretation of income and social and financial support, and my learned friend saying that it's perverse to take ad hoc assistance into account when it comes to assessing how much a person has in any particular month. Because he said if somebody's been given a donation to help them get out of poverty, it's not fair or it's perverse, in his words, to take that money into account when deciding how much they have access to. But my learned friend for the first and second appellants made the point that this is a month-to-month application. Your means are assessed every month, not every year. So your circumstances can change. And so in 1 month you can be above the threshold, and in the next month you can go below the threshold. Treasury says in its answering affidavit that that is a reasonable mechanism to try and balance the fact that on the one hand there is insufficient money available to make this grant more widely available, but on the other fact, you're trying to help the most desperate in need. So Treasury says, first of all, you must accept when you're talking about those desperate in need, all grant recipients must be taken into account. And Treasury says that they have taken the reasonable decision to prioritize the other beneficiaries of social grants, because the people who are the beneficiaries of this social grant are at least in principle capable of earning money from work. Children, old age pensioners, disabled people, etc., those people do not have an alternative mechanism to earn a living. And Treasury says in its answering affidavit that the most desperate in need have to be prioritized. But then, within the context of the beneficiaries of this grant in particular, Taking people's donations and other short-term income into account is not perverse. On the contrary, it's a mechanism to make sure that the resources can be stretched as far as possible, because if you don't have that mechanism, the resources won't be there at all. It's to make sure that at least somebody who can afford the basics, the very, very basics in 1 month, is not as desperately in need as somebody who has literally no other source of income. And I just want to recall the words of Justice Sachs in the Subramani decision. It was a concurring judgment, but it would be well to remember his point where he said, the inescapable fact is that if governments were unable to confer any benefit on any person, unless it conferred an identical benefit on all, the only viable option would be to confer no benefit on anybody. So it's the point we're trying to make is that if you have finite resources, the most desperate in need must be prioritized. Grootboom itself says that. And then within that context, a person who gets a donation of 2,000 Rand is clearly not as desperate as someone who has less than 624 Rand in their monthly earning and therefore qualifies. So that, with respect, we would submit is not perverse. It's in fact, it's a feature of the system which makes it reasonable. Then just on the other issues to do with, for example, the online applications and what my learned friend describes as barriers which are put in place for people to receive it. We have to be very careful, and I'm mindful of time. I'm going to try and make this my last or my second last point, but we have to be careful about a bit of a slippage that can happen when dealing with framing here. My learned friend bends over backwards to say that they're not trying to reallocate the budget, they're not trying to be prescriptive, they only want to plan, they don't want to impose anything on Treasury. But then they also argue that there's 16 million people that are meant to be beneficiaries of this. They describe that as common cause. With respect, it's not common cause, and I'll come back to that in a moment, but they say that it's common cause that there's 16 million people who should be benefiting, and then they say that barriers have been put in place, deliberately so, to prevent people from benefiting. So when I'm talking about slippage, I'm saying that one has to try and follow through the logic of each component of the argument to realize that eventually it becomes unavoidable to say, in the mouths of the respondents, that only an inflation-based social grant that covers all working age people would be acceptable to them. Because the point is that as soon as you say it's unconstitutional, as the High Court said, to have a threshold of 624 Rand, as soon as you say it's unconstitutional, as the High Court said, that the payment is only 370 Rand, and as soon as you say that 16 to 18 million working age people by right have been told that they are entitled to this budget, to this grant, then the implication is that the money has to be found for all 16, 18 million people to be provided for. Treasury and the Department of Social Development frame the matter from the other perspective, which is to say, this is a temporary measure. It is not the same status. It does not have the same status as the other social grants, which have been designed to provide for people who are most in need. And it is a measure where a deliberate choice was made, both by Social Development, and Treasury supports this, to have an over-inclusive approach to preventing fraud, preventing abuse, and making the system work correctly. So in other words, a deliberate choice was made that there are payoffs between not using online and using online, between making resources available for people to go into the offices and not making them available. The decision was made to create an efficient, fast grant that's immediately available, but which is subject to checks and balances and verification to ensure that there is no abuse. And that is a reasonable mechanism to ensure that the resources are preserved for as long as possible. So, and if I can just give a reference, I don't know what my learned friend for the first and second appellants is going to address, but just to make sure this doesn't slip through the cracks, I just want to refer to two parts of the record to just make this last point. In the department's affidavit at paragraph 68 at page 1083, and it starts from there but it moves onwards. There's a
What paragraph?
68 onwards, starting at page 1083.
Thank you.
There is a detailed description about the online application process. And what what the department says there is that it took 15 years for 7 million people to be able to receive children's grants. But it took 6 months for the equivalent, in fact, 1 million more, 8 million people to receive this grant. So if you read those paragraphs, and I accept I accept what Justice Keatley said about the evidence in the department's answer. However, if one reads those paragraphs of the answering affidavit, one will see that the department explains that a choice was made to use a modern online approach, which had the trade-off that it could be rolled out very, very quickly because there was no need for people to come to the offices and submit paperwork and fill out application forms. And they make the point about how proud they are that 8 million people got coverage. So the point is I'm just suggesting with respect that one must be careful about taking one of these things in isolation and saying, well, why couldn't we have in-person applications as well? A human in the loop. If one reads those paragraphs carefully, and they could have gone into more detail, but if one reads those paragraphs carefully, they are saying there is a trade-off that has to be made. And if you put a human in a loop and you require in-person applications, there is a risk that it's going to prevent the rollout in an orderly, efficient way, and they give the children's grants and the other categories of social grants as an example. And then if I can just refer the court very quickly to paragraph 41 of SASA's own affidavit, their supporting affidavit. It's paragraph 41 at page 1183. Volume 6, 1183. This is SASA itself speaking. Justice Keatley asked if there was any justification based on lack of resources. In that paragraph, they don't refer to money, because of course SASA takes what it's given. It gets given an allocation and it must do its best with it. But what they say is that from a human resources point of view, if we had to accept people in person, it would overwhelm us. We do not have the human capital, we do not have the staff available to be able to deal with applications in person. So just to try and wrap this up and to now finally conclude, and I'm very grateful for the indulgence that I've gone over briefly my 20 minutes. But the point is that our submission is that if one leaves aside the notion that someone can come to the front of the queue, it was Justice Petz's question, and they can find out that they're number 350 in the queue and the money's run out. And so the board comes and it says, now we're closed for business. Let's leave that aside, because nobody is attempting to defend that. My learned friend, Mr. Marcus, pointed out that it's speculative on the papers. That's our argument. Is it speculative on the papers? It's never happened. But if one leaves that aside and one looks at the rest of the measures holistically, the online application, the bank verification, the approach to the fact that if you have a donation in a particular month, you will not qualify because in that particular month you are over the threshold. If you look at that system as a whole, our submission is that it is a reasonable reaction to the very, very, very harsh fiscal condition which has been made out very extensively in the answering affidavit. In a situation where the only way to fund a bigger increase in this grant is with either higher taxation, which Treasury says is not possible, or with borrowing, then one has to have a system which has trade-offs built into it. And Treasury's case is that there are reasonable trade-offs here. Social development's case is that the trade-offs are real, because having it as an online process has actually had a very speedy impact on how people can gain access to it. But we would say in closing that this court would have to conclude that the system as it operates as a whole is unreasonable to the point that it must be set aside, and then we'll have to decide what order it makes. And that's where the problem with the High Court's order comes in, which is to say that my learned friend is wrong when he says it's not prescriptive. Because if one looks at paragraphs 14 and 15, they set aside as unconstitutional the value of the grant and the value of the threshold. And then in paragraph 17, there's an order about the plan, and if one reads those items that have to be taken into account, it's impossible to say that it would be a lawful decision not to increase based on inflation.
Is this the conclusion?
Yes. And so we would say, once one accepts that you can't rejigger the budget in that way, then we say this is a plan with lots of trade-offs, but it's a reasonable plan, which on the jurisprudence of the socio-economic rights can't be set aside, as the court reasons.
Thank you, Mr. Frieden.
Thank you, Justices.
Yes, Mr. Van
I only want to address two issues. The first is the Rule 11 application.
Yes.
There is an application for what is termed the preemption affidavit to be admitted. We oppose that application. We put in heads of argument and we stand by those heads.
Yeah.
If the court is against us on that issue, we will, like Treasury, also ask for time. We will fit in with the timelines if the budget speech is admitted as new evidence and timelines are given to Treasury, then we'll fit in with those timelines.
Well, we're not saying we're against anybody at this stage. We're saying that if that point needs to be ventilated, then everybody needs an opportunity to file their papers so that we get the full picture when we make a determination.
Yes. So we stand with our heads of argument on that point.
And you also need time to file.
And we'll also need time to file. The second issue concerns the submission that there is approximately 1 million appeals a month, and the contention that there should be a mechanism to place new evidence in respect of those appeals before the appeal tribunal. We've made our submissions about administrative paralysis, and I'm not going to repeat those, but the SRD system is not built to accommodate documentation. If 1 million documents a month must be processed by SASA, the system will break down. The system is not designed to take physical documents. It will have to be redesigned. In the interim, 8 million beneficiaries are paid on a monthly basis. So we ask the court to take that into account when dealing with that issue. Those are my submissions.
Thank you so much, Mr. Evans. I'm thinking that maybe we should file an affidavit and proceed through the registrar with the request for the filing of the registrar. Just tell Betsy to jump. I'm assuming the issue of the filing of the affidavit through the registrar. Without somebody telling me 6 to 7 weeks for what. Do you understand? Well, I'm saying we will dictate.
Oh, okay, so what do you
Do you see what we can do? We can just yeah, but now he's saying that it's going to take 6 weeks. We don't have it anymore. Do you see what I'm saying? Because remember, they are saying exactly, it's urgent. Okay, if they don't agree, then Mr. Marcus? This aspect of the filing.
I know what you're going to say.
Yes, because if you don't agree, then I'm going to dictate.
Yes.
And that will be, I don't think you guys will like that. So is there some sort of agreement that can be reached? or else we'll then dictate through the registrar that this is the date that we want the affidavits to be filed, and this is the date when the reply will be done.
Can I suggest that really, and I'm not exaggerating here, not less than 3 weeks?
2 weeks.
Justice Mayor, I've given you some indication in my main address of what the budget entails by reference to Section 27 of the PFMA. We're going to have to explain that now in relation to the budget speech. If you tell us 2 weeks, we always accept what the court tells us. I'm asking for 2.
You're just fortunate because it would seem that this half agrees that 3 weeks will be sufficient.
and you've got the casting vote. There you are.
And I got the casting votes quite correctly. So it will be 3 weeks to file.
Yes.
Both the appellants to file, and thereafter you would have, Mr. Brickhill, you'll have a week. No, you can't have 2 weeks. You'll have a week to reply. Right. That will be respond and a week to reply. Right. In the circumstances, judgment is reserved after we've received the answering affidavits from the appellants in 2 weeks' time, and after we receive the reply a week thereafter from the respondents. Judgment is reserved, and thank you very much for counsel supplying us with the heads of arguments that made life simpler in these circumstances. And all that I need to say is that everybody travel safely back to their respective workplaces. Right, matters adjourned. Court will rise.
Thank you.